Good morning, all. This trial is in the matter of CFI 110-2025 and is being held by way of video conference before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this trial will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Matuk Basioni and Henwi. Lead counsel is Mr. Sajid Suleiman, and the defendant is represented by Habib al-Mullah and partners. Lead counsel is Mr. William Persifco. Thank you.
Thank you very much. You've agreed a timetable, I see.
We have, yes.
And are there matters that need to be dealt with before moving straight into the trial?
No. Mr. Persifco.
Oh, yes, so just one matter. Our witness, Mr. J. Rahman, who is due to give evidence tomorrow, is in fact in court today. So if we make progress in the trial, I would suggest he would be called today. And then potentially that would only leave closing submissions for tomorrow. Just the other thing, just to flag to the court, I'm looking at the camera straight ahead, but my screen is up here. So if I'm looking at your lordship, this is how I look at your lordship, if that makes sense.
Yes, I don't.
Apologies.
I eyeball you eye to eye in quite the same way, but that's okay.
Perfect. Thank you.
What happens with the witnesses, though? That's much more important. Anyway, can I just have the camera on the witness? Oh, I can see it there. That must be the witness box I'm looking at on the left, is it?
Yes, I think it's the one that says claimant on our screen.
Yes, exactly. Right. Okay. Well, that's fine. Excellent. So then there's no housekeeping and preliminary matters otherwise that we need to deal with, and we can move straight to the claimant's opening, can we?
Yes, my lord, could I check that you received the hard copy of the bundle that was sent?
Yes, I did. I'm so sorry, Mr. Sullivan. I should have acknowledged that, and I failed to do so, but thank you very much.
No, not for there's, in addition to the hard copy bundle, there's a supplementary bundle, which is only...
Yes, I've seen that, which has the full copy of the expert report from the defendant's handwriting expert.
That's right, yes. And there is an authorities bundle, which is also only in electronic format.
Yes, that's fine. Thank you very much. Well, in which case we can move straight on to your opening, I think, then, Mr. Sullivan.
Thank you, my lord. I will be very brief in opening because the issues are very narrow. There are really two issues for this trial. The first is whether the defendant received 5 million dirhams in payment. And the second is whether this claim is in time, depending on the different causes of action. There are three key documents, and I will turn to those very briefly now, because we say, in fact, those three documents reduce the significance of the witness evidence, which we will hear during the course of this trial. The first of those three documents is the agreement itself, the loan agreement. And in particular, if I take your lordship, please, to page 222.
Yeah.
The agreement begins on page 220, but it's 222 that I wish to draw two clauses to your attention. Clause 3.1 states that subject to the terms and conditions herein set forth, the borrower hereby agrees and acknowledges having received the loan, being an aggregate amount of AED 5 million dirhams, on the date of this agreement from the lender. The defendant does not deny that that is his signature at the bottom of that page, and that in fact he signed the entire document. That document is not disputed by the defendant.
Indeed.
The second key document is the promissory note, and in particular, if I may take you to page 258.
Yeah.
This sets out that the defendant acknowledges having received the value, and that is he has received 5 million dirhams, and that he will repay that sum. Again, not in dispute that he has signed that document. And over the page, over the page, on page 259, is the schedule number 1 to the promissory
Yes.
note, which sets out in no uncertain terms the date of the loan, the amount of the loan, that is 5 million dirhams, how much is outstanding, that is the full sum, and again, the defendant's signature, which is not in dispute.
Yeah.
The third and final document, which is perhaps the more contentious one, is the receipt, and that is at page 237.
Yes.
Forgive me, I think my page references are slightly off. It's page 267.
Well, the documents appeared all over the bundle, so.
They do. There's multiple copies of the same document. Page 267, this is the receipt, and it says, received from Mr. Karthi, that is the claimant, the sums of 5 million dirhams pursuant to, and there was a separate agreement between Mr. Karthi and a third party, Mr. Yuvraj.
Yes.
The defendant has signed that, and this is the contentious document because the defense, as it's currently pleaded, the amended defense in paragraph 7, states, and perhaps we can have a look at this, is at page 26.
Yep.
Page 26, paragraph 7.
Yes.
This paragraph 7 really is substantively the entirety of the defendant's case, which is denying signing the receipt dated 11th of December 2024.
Yes.
What the defendant doesn't say is that he signed something, but it wasn't the receipt. The reason we are no longer calling expert evidence is because both parties' experts now agree that the signature on the document we looked at, the receipt document, is the defendant's signature.
Yep.
And I want to have a very quick look at the defendant's expert report because it contains one additional point. This is the supplementary bundle, page 22, please.
Yes.
Paragraph 47 of the defendant's expert report. After confirming that the signature is authentic, he goes on to say that the technical findings indicate signatures on both the original copies were executed prior to the body text, strongly concluding. And I make 2 points on this, and I won't say any more than this. The first is that your lordship had not ordered expert evidence on this question. Only handwriting expert evidence had been ordered. And the order, which I won't take you to, but the order is at page 212 of the main bundle. Your lordship had ordered handwriting expert evidence. Both parties instructed handwriting experts. Both parties' handwriting experts confirmed that that handwriting is the defendant's. What is set out there in paragraph 47 of the defendant's expert evidence, we say, is outside anything ordered by the court. And in fact would be outside his expertise. It's not clear how he reached that conclusion. And so we ask that the court entirely disregard anything outside the handwriting expert evidence that's been ordered. What's also curious about paragraph 47 of the defendant's expert report is that this isn't the defendant's case.
Yeah.
At no point had the defendant pleaded that he signed a blank document, and then text had maybe inserted subsequently. And it's not clear whether I suppose we will hear that later today, whether that is in fact the defendant's case, that he signed empty document, blank pages. The reason the claimant issued these proceedings, and I think the primary concern and where alarm bells started ringing for the claimant, was last year on the 22nd of May, 2025, for the first time, the defendant denied having received any money at all. At no point prior to that had he said, well, we haven't received any money. What money do you speak of when you say you want your money back? And that is why these proceedings were issued. And I'll conclude with this one point, which will be the only reason I'm setting this out is because it will be relevant to perhaps my learned friend's cross-examination, is that the defendant, your lordship may recall, during the document production sought to obtain documents relating to the source of the 5 million dirhams.
Yeah.
And your lordship had quite rightly said that that's not an issue in this trial. The defendant then again made a witness summons for the individual who provided the funds to the claimant, the £5 million cash. And your lordship set aside that witness summons, again reiterating that the source of the funds is not an issue that's live at this trial. And so I say that there should be no cross-examination questions that in any way stray into going to the source of funds. And if there are, then, and I hope my learned friend will forgive me, I will be interrupting to point out that the source of the funds is not in dispute in this trial.
The fact that the loan is made in cash.
Yes.
And the fact that on the claimant's own evidence, lying behind the loan is his arrangement with Mr. Keyan, if I pronounce his name correctly. And the purpose is for investment in property in Dubai with a sharing of the profits, if there are any, on the investment. If all that's correct, I have no idea whether that involves any breach of Indian exchange controls or anything of that kind. And none of that is relevant to the current situation. But there is no plea of illegality of any kind that I need to think about, whatever the source of funds may be. Is that common ground between the parties? Well, I assume it is, because no one's pleaded illegality.
Yes. Well, exactly right. And I think illegality will be a problem probably for both the claimant and the defendant, which is why neither has pleaded anything.
Indeed, and I understand that. I mean, something which is expatially illegal by DIFC law, I would probably have to take account of in any event. But as matters stand, although one is always unhappy about the cash transactions, for current purposes, I just have to go on the evidence and make a determination.
That's right, yes. And in fact, it's the claimant's case that it was the defendant who wanted the cash payment.
I understand that that's an issue between the parties, but yes, I understand the point. There's an issue there. Yeah,
absolutely. All right. Okay. Well, that's all I will say. I will also just as a housekeeping point, there are 4 witnesses, as we know. My lord, I propose for ease of reference that I'm going to be referring to the claimant as Mr. Karthi. That's how he prefers to be addressed. It's Mr. Karthi, and the second witness for the claimant as Mrs. Kavicha. I think this will make everyone's life much easier. Mrs. Kavicha will be his wife. Yes. And with my learned friend's permission, I will refer to the defendant as Mr. Ahmed.
Is that how he likes to be referred to, Mr. Prasivka?
Yes, that's fine.
Yes. And Mr. Prakash, I don't have a strong view, but Mr. Prakash Rahman, yes.
Very good. Are you going to say anything about the limitation case at this stage or not?
I was going to leave that for closing submissions. That's, of course, where a lot of the defendant's emphasis is. But I was proposing to, other than to say that one of the key issues is that the denial of receipt of funds only, in fact, happened on 22nd of May, 2025.
I realise that.
And that we say is the quick trigger point at which the cause of action accrued. But I'll address in greater detail in closing. I think once all the evidence is in, it can be addressed more comprehensively.
Yes, there is just one point I wanted to raise, which I don't think is covered specifically in the evidence, or indeed in the submissions. I'm looking at the loan agreement, and wherever you want to find it, I'm actually using the first copy in the bundle, which is attached to one of the readings, I think, or maybe the expert evidence. But anyway, the point is that clause 3.3, and looking at 3.3 little c, the lender shall have the right to demand repayment at any time upon giving the borrower 30 calendar days notice. The borrower shall, quote, to the extent it's possible, upon receiving a demand for repayment before the 5th anniversary of the date of this agreement, pay the repayment amount within 30 days of receiving such notice. If no demand notice received by the lender, the borrower shall pay within 30 days of the 5th anniversary. So, on the basis that the agreement means what it says, and there's an investment made in property, then on receipt of a 30-day notice within the 5-year period, the borrower only has to repay, quote, to the extent it's possible, which presumably would mean realising the investment, which could theoretically take longer than 30 days. In fact, in the ordinary way, if you were investing in residential property and you buy in units, flats, whatever, you would assume it probably would take more than 30 days.
Yes.
If there's no demand made at all within that period, then you've got a 5-year period plus 30 days for repayment. Now, what we have here is a demand that's made within the within the first 5 years. In fact, I think probably 2 or 3 demands that are all made within that timescale. No suggestion of, quote, impossibility. But I just wonder what any of that clause does in relation to a limitation period.
Yes, no, I take your lordship's point.
Maybe it's best explored after we've heard the evidence, but I just have that point in mind and would like probably, not now, but probably in closing, the parties to address that as to whether it has any impact once we've heard the evidence on limitation questions.
Thank you. Yes, I think I will address that specifically in closing.
Yeah, it's the words, obviously, to the extent that it's possible, that create a potential, potential room for argument of some kind.
Yes.
All right.
Yes, absolutely. So that will be a point, yes, we can address in closing. Yes.
Yeah, very good. Nothing else you want to say at this stage, then?
No, nothing else. Thank you.
Thank you very much. Mr. Pacifica?
Well, thank you very much, Your Excellency. So I think I fully agree with my colleague. Essentially, there are 2 issues at stake in this case. The first is whether or not 5 million dirhams was in fact advanced. And the second was, if it was, is the claim statute barred? Now, I would try to emphasize that I think the claimant's case has evolved slightly over time. But let me just say what the claimant's case is as of right now. His case is as follows. He and his wife met with the defendant and Mr. Prakash at offices in Dira on the 11th of December 2014. Again, there were 4 people at that office, and at that meeting the documents were signed. This includes the agreement and it includes the receipt. Then, very importantly, the claimant's case is that no money was in fact handed over at that stage. Rather, what happened was the parties broke up, I suppose, and then the claimant returned back to the office approximately 1 hour later and then delivered the cash. Could I draw the court's attention to page 105 of the bundle? And this is the claimant's trial witness statement. And the court will see at paragraph 18. And just to quote there, the 5 million dirham cash was advanced to the defendant later the same day, approximately 1 hour after the signing meeting described above. The defendant and I met again at his office, just the 2 of us. My wife and Mr. Jarman were not present. I delivered the AED 5 million in cash to the defendant in a brown rucksack containing bundles of 1,500 dirham notes, and the defendant accepted the funds. So again, on the claimant's own case, the money was handed over after the receipt was signed, and the money was handed over after the contract was signed. So essentially, even taking the claimant's case at its height, my client's signature on the contract and my client's signature on the receipt do not, in fact, evidence that funds were actually received. So then what happened? The claimant then did nothing for approximately 2.5 years. The court will be aware that there's been extensive disclosure in this case. We sought disclosure of all WhatsApp messages and other communications between the parties. And the first we then hear about this loan agreement is on this in the written record, is in the 28th of May 2017. And can I draw the court's attention to page 269 of the bundle? And the court will say this is the written demand.
Yeah.
So there is a serious evidential gap between the 11th of December 2014 and between the 28th of May 2017. There are no written documents that in any substance whatsoever refer to this agreement or refer to cash being handed over. Now, the first...
That may or may not be surprising, Mr. Pasifka, in the context of something that's taken place in cash. The comments I made earlier about cash transactions are relevant in that context, aren't they?
Well, yes, but I would have thought that if I had handed over 5 million dirhams in cash and there was some sort of dispute about whether or not that sum should be returned, I would have thought there would at least be some sort of WhatsApp message. I mean, I'll take the court now to the WhatsApp correspondence. The court can find the relevant WhatsApp correspondence at page 315 of the bundle.
Yep.
Now, I should say, the correspondence starts at page 314 of the bundle, and then it goes to approximately page 322. And
yes, I have read it all, Mr.
okay,
Pasifka.
perfect. I would ask the court to read that in its full context. And
Yes.
what the court will then see, that in my submission, the first thing that you can ever get any reference whatsoever to cash, I think comes on page 315. It's midway through the page, and I think it's dated the 21st of July 2017. And there the claimant says, "Can I collect the cash from you tomorrow?" I would add it's very unclear as to precisely what is being referred to. And then my client says no. The claimant says, "When am I going to get it? There is too much pressure. Otherwise, Monday I have to be in India to transfer my property. By trusting you, I am losing everything I have." And then he goes on to say, "You have been saying same thing."
I was going to ask if you have any. As a matter for the witnesses at the end, what on earth is meant by late to see what will happen from Mr. Ahmed?
Well, it's very unclear. If the court looks at the full context, if the court goes back
Yes.
to the top of the page to the 15th of June, and again,
Yes.
there's obviously reference to another property deal. The court can see at the top of
Yes.
page 315, they are talking 25 million, and then my client says no. And there's actually a photo attached, and if the court can actually see behind this correspondence the various photos that were exchanged. So the documents that are not just text, and again there are references to plots of land, all of these different things. So it's very unclear to me precisely what is being referred to here, at least on the face of these documents.
I didn't, I confess, gain anything much by looking at the photographs, because without some explanation,
Yes.
they don't tell you a great deal, except obviously that the parties were talking about property of some kind. They were talking about the market. They were talking about an advance on the land, which suggests a sale being made. But that's about all I could read into it at this stage.
Yes, and I think...
Anyway, maybe it's all better addressed after the evidence. But
Yes. Well, what I would simply say, this isn't really evidence of somebody who is effectively pursuing a debt. Given effectively there is a discussion, continuous discussion about what are definitely other deals, it doesn't really seem to me that effectively the claimant is saying, "Give me back my money." If the claimant really had advanced 5 million in cash, if the sums really hadn't been repaid, it would be strange that they're still talking about another deal as late as the 15th of June 2017.
Just remind me when the sale of the shares, his 51% in the company was made. Was that 2018?
Yes, the formal transaction was in 2018. I believe it's the 28th of May 2018. I just can get the exact date. I think it's May 2018. However, having said that, that was the final formalities that were pushed through. So again, there was not really an ongoing business relationship much after 2014. But I do submit that the final formalities were only pushed through in 2018. So I suppose that the key thing to emphasise is this cash was allegedly advanced. There are no witnesses to it, and then the first documentary evidence about the cash is May 2017, and then of course you have the WhatsApp messages beginning in June 2017. So again, approximately 2.5 years later. So naturally, from my client's position, the natural question that we would ask, and I think it's a very fair question to ask, is, well, where did the claimant get the money? Where did the claimant get 5 million dirhams in cash? It is very, very difficult to get 5 million dirhams in cash without leaving some sort of paper trail. So naturally, we sought disclosure. Now, could I go to the court's disclosure order, dated the 7th of May 2026, and the court will find a copy of that at page 76 of the bundle. So I should just add, this is requests 3 and 4. And so this is from your Lordship's disclosure order, but it's quite helpful because it's got the full reference schedule. So I just want to try to emphasize that just the process that was ongoing. So we made our initial request for documents on the 27th of February. And the court will see it request 3. We sought all bank statements, withdrawal slips, and records evidencing the withdrawal or transfer of 5 million dirhams. And if the court then turns as well to page 79, the court will again see request 4. And again, all documents evidencing the source of the 5 million dirhams alleged to have been provided. Now, I should just emphasize, at this stage, when we made this request, we had no knowledge whatsoever that the claimant's case was going to be that the money was handed over an hour later, after the receipts were signed. That case was only fully formulated on the 1st of May as of this year. So our request for these documents was the 27th of February. The court can then go on to see on the 13th of March, this is at page 76, the court can see the defendant's objection. And the court can see A, B, and C. And I would just take the court's attention to C, which is on page 77. And again, this is the 13th of March. This is as recently as the 13th of March. The defendant says, he goes as follows: the defendant admits signing the agreement and the demand promissory note, both of which contain express acknowledgements of receipt of the loan. The burden of establishing that the loan was not received, notwithstanding those acknowledgements, lies with the defendant. This request seeks to shift that burden. Now, when the claimant wrote that, I think all the parties assumed the case was, we received the money, following receipt of money we signed the receipt and we signed the agreement, or at least it was all part of one transaction. And I think as of the 13th of March, that seems to be the case, that the claimant is still advancing. And then, of course, your Lordship then went on to make a decision granting us, I would submit, I think, which was a reasonable disclosure request. And the court can see the court's order in the final column. And essentially what the court ordered was the court ordered the claimant to conduct investigations to find all the relevant documents evidencing where this money came from. And now, so where did the claimant get the money? Again, the claimant's position is it didn't come from his own bank account. It didn't come from the sale of an asset. It didn't come from, say, the management of a cash business or something along those lines. For the very first time, on the 1st of May this year, we can see the defendant's assertion. Could I ask the court to go to page 104 of the bundle?
Yes.
And the court will see at paragraph 14. The AED 5 million advanced to the defendant on 11 December 2014 was provided to me in cash by a long-standing friend and business partner with whom I've had dealings over a number of years. I explained to him the purpose for which the funds were required, namely in advance to the defendant for direct investment into buy real estate. So that's the first time in the proceedings we ever got any sense of the provenance of these 5 million dirhams, and this is when the disclosure process was substantially complete. And the court can then go in to see our letter that we sent after receiving this, what we thought was quite a remarkable witness statement. Could I ask the court to turn to page 214 of the bundle?
Yes.
So this is our request for further information from the claimant to the claimant's legal representatives. And the court can see at paragraph 3, we say, given that you've now suddenly for the first time told us that this money was advanced by a long-standing friend and business partner, and we say at paragraph 3, please provide, number 1, the full name and last known address of the individual described as the claimant's long-standing friend and business partner, referred to at paragraph 14 of the second witness statement, and B, whether the claimant intends to call that individual as a witness in these proceedings. And if the court turns the page to page 215, the court will see the response from the claimant's legal representatives. And this is for the very first time that Mr. Kachiapan is identified. And again, it is identified that he resides in India. So obviously on our case, Mr. Kachiapan is a key witness. And of course, we then issued a witness summons, and of course, as the court is aware, and I think we do agree with the court perhaps does not have the power to compel an Indian citizen to attend before the DIFC court. But what I would just emphasize is the failure of Mr. Kachiapan to be here today is a significant lacuna in the claimant's case. And what I would just also emphasize, and this is quite important, is subsequent to this correspondence, the claimant produced a bank statement from Mr. Kachiapan. And could I ask the court to turn to page 429 of the bundle?
Yes.
So after this correspondence, this was then produced, and the court can see it's effectively a bank statement from Mr. Kachiapan. It's dated from 2013 to 2014. And yes. I want to make just 2 comments about this document. Number 1, it shows the claimant and Mr. Kachiapan are still very much in contact. If effectively, after this correspondence, the claimant was able to contact Mr. Kachiapan and get him to deliver his bank statement, that shows that Mr. Kachiapan is not lost, not out of contact. They're very much in contact. But what's so much more important about all of this, if Mr. Kachiapan is able to show a bank balance in his account for, I think it is approximately 6.8 million in December 2014, why can he not simply show a withdrawal slip? Or why can he not show any evidence that he transferred this money to the claimant, and then the claimant used that money, I suppose, to give to my client?
So, of course, there is an obvious explanation, which is that all of this is taking place in cash, and whether for reasons to do with Indian tax or anything else, that's the way that the matter proceeds. I mean, Mr. Pacifico, I start from the position that a cash transaction has in itself elements that raise suspicion, and therefore lying behind this may be all sorts of tax issues of one kind, with which I'm not in the end concerned. But don't get me wrong, Mr. Pacifico, I have your point about there being no written evidence. But all I'm putting to you for your comment either now or in closing is that on the claimant's case, that may in fact not be surprising.
Yes, I would just simply make the submission now that it's very hard to take 5 million dirhams in cash without leaving some sort of paper trail.
I've got that. Yeah.
The fact that there is no paper trail, and the fact that we've gone to extensive lengths to get a paper trail, and the fact that none has been produced, I would invite the court to draw its own inferences from that. That's I think how I'd put it.
Indeed, I've got that.
Now, the next issue. So, the next issue then I would like to discuss then is limitation. And just to make one quick point, I think my friend argues in his submissions that Nest Investments is authority for the proposition that limitation is governed by the lex causa and not by the lex fori, and I think we accept that position as of right now. one thing I would just say is, while the contract, of course, is governed by English law, there is a question mark as to the other causes of action. I don't necessarily intend to get bogged down in that now, but in any event, both DIFC law and English law are quite similar on this point. Both have a 6-year limitation period, and both contain the standard exemption for fraud. So I don't think a huge amount turns on that. So I would propose to address limitation now as a matter of English law. Of course, if something turns on it, perhaps we can address that in my closing submissions. So obviously the agreement is dated the 11th of December 2014, and it provides that the loan is repayable on demand. So we say a demand was issued on the 28th of May 2017, seeking payment within 30 days. No payment was forthcoming. So we say the cause of action accrued in June 2017. Again, this is all on the assumption, to your Lordship's point on impossibility, again, no issue of impossibility was raised at the time. So we simply say that does not apply. Now, with respect to, if we conclude the cause of action accrued in June 2017, this case is clearly...
I suppose, Mr. Pasivka, if he never received the money, there's an impossibility of repayment.
Well, exactly.
But that may be a joke point rather than a real point for argument in the context of construing the agreement.
Exactly, and obviously we face a slight limitation because we're denying completely receiving the money ever. But then, if the court concludes that this state of fact did happen, we also say it's statute barred. So we're effectively arguing limitation on a case that we say doesn't exist. But I will just continue with the point. So if the claim
but the interesting point which arises, and again, there's no point really in anticipating the evidence of this, but the interesting point arises as to if money was received, what happened to it. And that's all I'll say about that at this point. I have no doubt that will be explored in evidence.
Yes. So I suppose if we conclude the claim is statute barred and we conclude that the cause of action arose in June 2017, there really are only two ways in which the claimant can get over that. The first is through acknowledgement and the second is through fraud. I think the court will be very well aware of the law on that. Now, with respect to acknowledgement, I would just note that the claimant specifically amended its pleadings, I think at your Lordship's invitation, to plead acknowledgement of debt. At least that's what was, I think your Lordship made that invitation at the original case management conference. And could I draw the court's attention to the amended particulars of claim, and the court will see that at page 17 of the bundle. And this is paragraph 13. Now, I don't necessarily intend to read this completely, but I don't necessarily see from paragraph 13 that there's a full amended plea of an acknowledgement of debt in that.
Well, I don't think Mr. Suleiman's relying on an acknowledgement of debt.
No, that's what I was going to say, that there's nothing in his skeleton argument about acknowledgement.
No, exactly.
No.
So, and I think the key point there as well, an acknowledgement needs to be signed. And so, first of all, the text messages don't acknowledge anything. And then secondly, that they're not signed. So I think acknowledgement falls away.
Indeed.
So the only then issue is fraud. Now, the key thing I want to try to emphasize to the court is that this was always a contractual claim. Could we go to the original demand on the 28th of May? The court will find that at page 269.
Yep.
And the court will find the original demand. Again, this is simply a contractual claim. Then later on in 2018, there was a letter from Clyde & Co. The court will find that at page 273. And again, it's the 29th of January 2018. And the court will see, again, it's a contractual claim in the Clyde & Co. letter. Then there was a Dubai court's notice dated the 1st of November 2022. The court will find that at page 277. The document is in Arabic, and actually there's no translation in the bundle. But again, my understanding, having spoken to colleagues, is again this was a debt claim. Now, you cannot claim that failure to repay a debt is fraud. If a failure to repay a debt is in fact fraud, I think that would certainly upend the common law legal system. And the agreement itself as most agreements for a debt do, it provides consequences for non-payment. Could I draw the Court's attention to page 231? This is the contract.
Yeah.
And again, consequences of default. So, again, this is very standard language in any debt claim. But how can you say failure to fulfill an agreement is fraud if that specific agreement lays out specifically what the consequences are for a default? I mean, essentially, any loan agreement, you are getting, say, cash in return for providing a security. And effectively, what you're saying is, give me the money, I will take the money, and of course there will be consequences if I default, and those consequences are going to be set out in the contract itself. Now, the claimant states that he first learned of the fraud on the 22nd of May 2025. Could I draw the Court's attention to the reply, and that's at page 23 of the bundle?
Yeah.
And I think the Court has that point. That would be at page, it would be, paragraph 33, apologies, of the bundle, and it's going to be paragraph 23.
Yes.
It is, the fraud was not and could not, with reasonable diligence, have been discovered until the meeting of 22 May 2025, when the defendant for the first time denied receiving the loan. And he goes on to quote the relevant section from the Limitation Act. Okay. However, the correspondence before 22 May 2025 is, I would say, replete with references to fraud. Could I draw the Court's attention to a letter dated 19 May 2025? The Court will find this at page 282 of the bundle. So if the Court sees, it's a letter written, it's 2 columns, Arabic on the right, and then English on the left. And again, this is the 19th of May 2025, so it's approximately 3 days before the meeting. And if the Court turns to page 285 of the bundle, the Court there's a very interesting passage here. If the Court is on page 285, let this serve as your final warning. Your persistent refusal to engage will be used against you in court to establish malicious intent and fraudulent concealment. Our client will seek maximum relief, including full damages. So the claimant, prior to the meeting, where the claimant claims it was the first time they discovered the fraud, the claimant is already using language of fraudulent concealment. And I would suggest that potentially an English common lawyer had something to do with the language in that letter. Of course, I don't know. That's only the implication that I can draw. Now, the other point about the discovery of fraud is that the obligations imposed by the agreement were immediate. Could I draw the Court's attention to clause 3.6 of the agreement? And the Court will find that at page 223 of the bundle.
Yes.
And the loan, and this is 3.6 at the bottom of the page, the loan made by the lender pursuant to this agreement shall be evidenced by 1, an undated check for the loan amount that is issued by a bank in the United Arab Emirates. And again, the obligation to provide a security check is quite common in the UAE, as Your Excellency will know. No security check was ever provided. And so again, effectively, if this agreement was signed, if the money was advanced, my client was effectively in default immediately. The next point to draw the Court's attention to is the obligation of the borrower to provide ongoing financial statements. That's at page 226. And
Yeah.
paragraph 5.0, again, the borrower shall deliver to the lender, A, as soon as practicable, in any event within 30 days after the end of each of its fiscal quarter, the unaudited annual financial statements. Well, again, no financial statements were ever provided. And so again, my client was in default, I suppose, in respect of this agreement immediately. And of course, clause 5.6, this is on the following page, provides for a right of inspection. And again, I don't think the right of inspection was ever availed of. So given none of this was done at the time, given that effectively my client didn't provide a security check, never provided any information, I would simply say that it's fair to say that the quote-unquote fraud could have been discovered. And it could have been discovered immediately. And I might just draw the court's attention even to the claimant's amended particulars of claim. And this is at paragraph, this is page 20 of the bundle. And
Yes.
paragraph 25A, the defendant knew at the time of signing the agreement that he did not intend to provide the security required under clause 3.6A as evidenced by his quote-unquote immediate and continuing failure to deliver the check. So, on the claimant's own case, as pleaded, the default was immediate. And what I'd like to do now is to go to the WhatsApp correspondence. And could I draw the court's attention to page 315 of the bundle? And then we were on this page at the beginning of my submissions, but I want to refer that it was just on the issue of limitation. So, right in the middle of the page, on the 21st of July 2017, at 4:46, the claimant states, quote unquote, "By trusting you, I am losing everything I have." So clearly, as of 2017, the claimant was, quote unquote, aware that my client was dishonest and was saying that by trusting him, he's losing everything that he has. And so if the court takes that as the date of knowledge, the claim is clearly statute barred, because the claim would have had to have been issued in 2023, in July 2023. And we can even...
You're reading a lot into that, aren't you, Mr. Pasifka?
Well,
by trusting you, I'm losing everything I have.
If the case is that when could he have practically discovered the fraud, that's the test under the Limitation Act. So when could the claimant with reasonable diligence have discovered the fraud? Well, we would say immediately, because no check was provided, no quarterly statements were provided. And then in correspondence, as of 2017, the claimant is clearly saying that my client is untrustworthy.
Yeah, you've got to be a bit more precise, I think. And again, it may be best addressed after the evidence has been heard. But the plea is of a misrepresentation of intention at the time of entering into the agreement, the intention being not to repay.
Yes.
And the question then is, when was that discovered, or when should it, with reasonable diligence, have been discovered?
Yes.
At least that's the way I'm reading the pleadings at present.
Yes. And
so you can say that the failures to do other things are straws in the wind, or however one wants to put it, something stronger, clear indicia of such a fraudulent intention. But I'm sure that's not your primary case.
No.
Which is why I suspect all this is better dealt with in closing.
Yes.
But what I am suggesting to you is that when one comes to analyse this, you've got to be quite careful what it is that you say is being either deliberately concealed or where the fraud actually lies.
Yes. And the point that I would make is that the quote-unquote fraud happened in 2014. There are no allegations of continuing fraud. So, for example, or perhaps I would say there's no allegations. What I should say is my client did not make representations continuously. Say, I've invested this money here, I've invested this money here. There's nothing of that in the evidence. So the question is, what if we were going by the tort of deceit, my client would have had to make representations. As far as I can tell from the pleaded case and the evidence in the bundle, the only quote-unquote representations were made at the time of the loan agreement in 2014. And so then the question is, when could those representations have been discovered with reasonable diligence? And I think the answer is, well, it didn't get a security check, didn't get quarterly statements. The claimant's words, quote unquote, by trusting you, I'm losing everything. And I should say, this is not a once-off representation. Could I ask the court to go to page 318 of the bundle?
Yeah. Yes.
And this is the 30th of August 2018. So again, this is still a representation more than 6 years. This is a quote. This is a discussion more than 6 years prior to the claim was issued. I swear Allah won't forgive you for what my family is going through because of you. You have been giving me
Yeah.
nothing but false promises. So these are the claimant's own words. So I would simply say that a person who states that could, quote unquote, with reasonable diligence, have discovered the fraud. And both of those representations place the claim out of time. So with all of that in mind, those are my opening submissions, unless the court has any further questions.
No, again, I draw to your attention the terms of the loan agreement that I drew to Mr. Suleiman's attention about repayment to the extent possible, but not necessarily for your argument or comment at this stage, but simply that when one comes to the closing, one needs to be looking at the agreement as a whole in that context, and after we've heard the evidence.
Yes, but I will address that point in closing, I think, would be the most sensible thing to do.
Yes, thank you very much, Mr. Pasifka.
Thank you.
All right. So,
I know there's one document which is not in the bundle, perhaps should have been, is your decision when setting aside the witness summons from 3 weeks ago.
right. Yes.
It's not in the bundle. That it is. It's a document I imagine that the registry will have on the record.
I'm sure they
It's a
will.
It's a 3-page.
I probably have a copy of my draft here somewhere. Anyway, we don't need it for current purposes.
Well, the reason I was bringing it to your attention for the current purposes was just before we start cross-examination, because I think Mr. Pasifka will be going down the line of questioning the source of the funds, which that decision from 3 weeks ago by your lordship, paragraph 4 of that decision,
well,
again makes the...
Is it not in the case bundle somewhere, the electronic bundle?
It's not in the trial bundle. It may well be in the...
Oh, it'll be in the case management system under events, probably somewhere.
Possibly. I don't get access to that as counsel for some reason.
Your Honor, I'm sending the order to you right now via email.
That's very
thank you.
kind. Thank you. If you could send it to everybody, that would be very helpful. Then everybody has it to hand. Thank you very much.
Thank you. Thank you, yes. And it's paragraph 4 in particular, where your lordship essentially said that the source of the funds is not relevant, and the ability of the claimant to make the loan is not an issue. The question is the receipt of the loan, not the making of the loan. That's a trial issue. And I think it's a point that we don't want relitigated by the defendant for a third time, and particularly if there's going to be extensive cross-examination questions. I saw my learned friend again decide to make extensive submissions on that point. And it was suggested that the case had perhaps developed since your lordship's decision. This decision is from 3 weeks ago. Nothing has changed since then.
Well, Mr. Pasifka, you have heard the warning across your bows. If you want to address me on the point now, you can, or we can wait until you raise questions that are objected to.
Yes, perhaps it's best to issue the questions and then let my colleague object to them. Obviously, the source of funds and where the money came from is a key issue in this trial. So,
well, it is and it isn't. There is only one real question apart from limitation, and that is, was the money handed over?
yes. So the question. So obviously, if there are no documentary references whatsoever to where the money came from, I think I would be inviting the court to draw inferences from that.
Well, I understand that. You have, of course, the reference in the receipt itself, which I'm not quite sure what your case is going to be about that, but there it is on the face of it. I'm sure your client will be cross-examined on that.
Yes, well, but bear in mind the claimant's case is the receipt was signed and the money was handed over an hour later. So even on
I've got that. Yeah, well, let's see where we get to. I suspect we'll find ourselves having a debate in the middle of your cross-examination, but if that's the way you want to deal with it, that's fine.
I think what I'm trying to avoid is any contradiction between what is, in no uncertain terms, your lordship's decision from 3 weeks ago.
Yes, and I'm not resiling from that decision at all. And I think Mr. Pasifka is aware of that. So
yes.
Whether his cross-examination crosses the boundaries, I guess we'll have to wait and see.
Yes, okay.
All right. In which case, we move on to the evidence, do we?
Yes.
That's right, yes. And it's the claimant's first witness, that is the claimant himself, Mr. Karthi.
Yes. Right, Mr. Karthi, are you going to swear an oath on a holy book, or are you going to affirm?
Yeah, I can swear it on oath. There's no problem.
Well, as long as you've got the right holy book there, then the oath can be administered to you.
Thank you. Please confirm your full name and occupation for the court's record.
Karthi Keyan Venkataramana.
And your occupation, please.
I'm a businessman.
Thank you. Please repeat after me.
I swear by Almighty God to say nothing but the truth.
Thank you. Please be seated.
Shall I proceed directly with my course, or is there any other issues arising?
Well, you better affirm his witness statements.
Yes.
Mr. Sullivan, if you can get him to do that.
Absolutely, no, absolutely. Mr. Karthi, in the trial bundle, if you could please turn to page 102.
102. Should I search it?
Once you've reached page 102, if you could please let me know.
Sorry?
If you could confirm once you are on the page.
Yeah, 102 is the page number I'm seeing.
Thank you. And that's as a second witness statement of Mr. Karthi. And at page 108, please, the last page of that witness statement. Can you confirm that is your signature?
108. No, I think number is wrong here. The 102 is the...
102 should be the first page of the witness statement. 108 should be the page with the signature. I'm looking at the red numbers on the right-hand corner, not the small number on the bottom of the page.
Right one.
It's the red number.
Yeah, we wanted the red number.
102, and this is showing the signature experts report.
The 108.
108.
Have you got the? Is it the trial bundle you have in front of you, or the supplementary bundle?
If you keep going down.
It should be the main trial bundle, which is 430-page PDF.
No. May I please take them out?
No, this is the one, I think. This is the 527 pages. Let me check the other
Mr.
document.
Suleiman, can I please confirm again the red numbered, what's the page number in red?
102, please, is the first page.
He should be looking at his witness statement of 102 and 108. 108 being the signature page, 102 being the first page of his second witness statement in the trial bundle.
There is an issue with the bundle. It's not corresponding to the page number. If we could just take 1 moment to figure this out.
Yes, all right.
Sure.
It's okay. Thank you.
Yes, the electronic bundle is different.
It is downloaded as a PDF, however, it is not corresponding with the numbers.
No, it's not.
We have a hard copy bundle, if that would assist. We can simply give.
Well, I think that would be simplest because the electronic bundle is, on the face of it, different. Let's just see what's going on. Something odd about it. Very odd. I think probably if we can proceed with the hard copy, that will make life much simpler.
Yes, we can do that, and then in the break I can figure this case bundle out in the system.
Yeah, something's gone wrong with the, because it is showing something different at 1:00. Oh, now here we are, something different. Very odd.
I'm looking at page 102 now.
Okay, thank you. So this is the second witness statement, your second witness statement, and final page 108. Can you confirm on page 108 that is your signature?
Yes, it is.
And do you stand by that statement today?
Yes, I do.
Thank you. And then over the page 109, please.
I'm on page.
So the third witness statement of Mr. Karthi, and then page 112, please. Can you confirm that is your signature?
Yes, it is.
And can you confirm you stand by that statement and confirm its accuracy?
Yes.
Thank you, my lord.
In the electronic bundle, his second witness statement appears at page 57, and his third witness statement at page 64. Oh, that I see. It's the numbering at the top and the bottom that's different. So the electronic bundle is, what's it doing? Yeah, well, anyway, no matter. It can be sorted out during the break.
Yes,
we all,
I think if we...
Mr. Pasifka, I hope this isn't going to prove any problem in cross-examination.
No, they're not that.
As long as you use the hard copy bundle, it'll be all right.
Yes, we have the hard copy bundle, which we can use. Shall I begin?
Very good. When you're ready, yes, thank you.
Yes, well, thank you, Mr. Karthi. Firstly, I should say I don't intend to be terribly confrontational, and I would like just to give you the opportunity to essentially tell the court your story. So can I just start by trying to summarize your case for you, and then you could just tell me if you agree with that. So your case is that you met the defendant on the 11th of December at his offices in Dura, correct?
Yes.
And then at that meeting was your wife, and then Mr. Rahman.
Yes.
And then at that meeting, documents were signed.
Yes.
The agreement, the receipt, and the promissory note as well, correct?
Yes.
Then your case is that the meeting broke up, and then 1 hour later you returned to the meeting. And at that meeting, you brought, the only person there was the claimant, correct?
Yes.
And then at that meeting you delivered cash totaling 5 million dirhams.
Yes.
So can I just ask you, so what can you just explain to me the type of bag the cash was in?
It was in a brown color rucksack.
So please just describe it more. Could you describe it? Was it a big rucksack, a small rucksack?
It's a medium to big rucksack that we used to use for carrying to our office. And I think, if I'm not mistaken, the make is Jansport.
Jansport.
Yeah.
And so how heavy was the rucksack?
Probably about 9 kilos.
Okay. And where did you get the money that you... So you left the meeting broke up, the four of you. Where did you go to get the money?
The money was delivered to me the previous day.
Who was the money delivered to you by?
One of Mr. Yuvraj's associates.
And where did he deliver the money to you?
It came to my office,
Where is your office?
Alco's industrial area.
So how long would it take to get from Al-Quoz to Dira, roughly speaking?
To Alco's to Bardubai, you mean?
Yes.
Alco's to Bardubai, in normal circumstances, if there are no traffic, it's about 20 minutes drive.
So your evidence, just to understand, is that you went to Al-Quoz personally, or the money was delivered from Al-Quoz to Dira?
No, I went to Barsha from my residence to pick it up and bring it back.
So the money was in your residence?
Yes.
So several days before the meeting, the money was delivered?
To my office, and it
To
was
your
carried
office.
to my residence, where it was kept under custody, and later on I brought it and gave it to him.
So you, in 1 hour then, went back to your residence in Barsha, and then
Yes.
you collected the money,
Yes.
and then you brought it back to Dira.
Yes.
Why did you not bring the money with you at the time?
Because I did not want to leave such a big sum in the car.
How many so did you have a driver, or did you drive yourself?
I drive myself.
So the money was in your residence, you went to the meeting with your wife, the two of you,
Yes.
then did the two of you go back home?
Yes, because she had to pick up my child, so I had to drop her at home, pick up the cash, and then come back and hand it over.
Okay, and your wife will testify that she traveled back home with you on that day? Okay. So the evidence is the money did not come from one of your bank accounts, correct?
No,
And it wasn't obtained through running a cash business,
no,
and it wasn't obtained through the sale of a property or any other asset,
no.
and it was provided to you by your business partner, who is Mr. Kachiapan, is that
Yeah.
correct? So when did you first tell your legal team about this?
Sorry,
I'm not sure you're entitled to ask that, are you?
Absolutely not. No.
Well, well, we'll put it another way. I'm correct in saying that there's no mention of Mr. Kachiapan in your particulars of claim, correct?
I'm not sure I understand your question clearly.
So when you issued these proceedings, in the legal documents that were used to issue these proceedings, there was no mention of Mr. Kachiapan, correct?
The defendant wanted to know the source of funds. That is the reason why there was a receipt made wherein it indicated my relationship with Mr. Kachiapan.
So the first time that this was before the court, I think you would agree, was on the 1st of May, that this allegation about Mr. Kachiapan.
I'm sorry,
The first time that we, or the court, or my law firm knew about the allegation that the money was paid to you by Mr. Kachiapan was in your first witness statement dated the 1st of May, correct?
no, it was always there in the contract itself. The contract had, the last page of the contract had Mr. Kachiapan's name, and he was the one who gave me the money.
The agreement has Mr. Kachiapan's name?
Yes,
Are you sure about that?
yes, the last page
Are you
is
talking
where
about,
it is very clearly mentioned that this 5 million came to me between an agreement between me and Kachiapan, and Mr. Almula signed for it.
do you have a copy of the contract before you?
It is there in the bundle.
Yes. Could we go to the contract? I'd like to know what you're referring to specifically. I believe the contract is at page,
And it is the same page for which we had a meeting in my lawyer's office, Matuk Basuni, on, I think, sometime in March, February or March.
so the contract begins at page 175, correct? I think you should have that in the bundle before you. This is the agreement dated the 11th day of December
It's not
2014.
It is there in our copy.
So is just to confirm, is your evidence that Mr. Kachiapan is referred to in this agreement? I might just ask Mr. Kachiapan to find the pages himself as opposed to his legal representative.
No, in fact, that particular copy was inspected in my lawyer's office with me bringing the original, the copy, and then there was 2 dots missing between the original document
can we
submitted.
just, sorry, just take a step back. So there is an agreement dated the 11th of December 2014. This is
Yeah.
a standalone document.
Yes.
It has at the back of it a document entitled Promissory Note. So can you confirm that Mr. Kachiapan is not mentioned in the agreement?
On the main agreement, no.
Yes.
When the source of funds, what the defendant wanted to know, there is a separate receipt for which he has acknowledged.
So your evidence, if I understand it then, is that you told the defendant as of 2014 where the money was coming from.
Yes,
Okay, so
he was fully aware.
okay, when did you tell the defendant that?
Before the contract was even made, it was discussed, and then based on that only the contract was made.
So can we then go to the, I think you're referring to the receipt, is that correct?
No, there was a document which has Mr. Almula's signature. That document is not attached here in this trial bundle.
What's the reference for the receipt? What's the page? Could you turn to page 267 of the bundle, please?
Yes, the 267.
So this is your evidence that this was effective evidence that my client knew that the source of funds was in fact Mr. Kachiapan.
Yes.
Could you just read aloud the receipt and what it states?
Received from Mr. Karthi and Venkataraman sum of dirhams 5 million only AED pursuant to the agreement dated 11th December 2014 between Karthi and Venkataraman and Yuvraj Kachiapan.
So the agreement between yourself and Mr. Kachiapan
Yes.
was actually dated the 11th of December. Because I believe your evidence had been you agreed beforehand, correct?
We agreed beforehand, and the 11th of December is dated on the day the money was delivered.
But Mr. Kachiapan was he in Dubai on that date?
No, he wasn't.
Where was he?
He was in India.
He was in India. So the 5 million dirhams in cash, which was sent to you by Mr. Kachiapan several days before this agreement, it was sent to your office in Al-Quds, and then it was sent to your hotel, or your house in Barsha. Your evidence is that while all that was happening, Mr. Kachiapan was in fact in India.
Yes.
And so Mr. Kachiapan clearly trusted the people who were moving the cash for him.
Yes.
Do you know who those people were who were moving the cash?
I don't remember.
You don't remember?
It's too long.
Did you have a phone call with Mr. Kachiapan?
I have had multiple phone calls with him.
So if obviously someone wants to get 5 million dirhams in cash, could you just describe the process? Did you call Mr. Kachiapan up and did you say, I'd like the money, or how did the process work?
I explained him the opportunity that has come up, and he agreed. And initially he wanted to do a bank transfer, but since the defendant insisted that he needed the money in cash to invest it on a desperate sale property, we had to arrange for cash.
And the money came from, where was Mr. Kachiapan's office in Dubai?
He doesn't have an office here in Dubai.
So how did Mr. Kachiapan get 5 million dirhams worth of cash?
He's an investor.
So
He invests in properties, he invests in companies.
And so there's no written record of where the money came from?
I didn't ask him.
So Mr. Kachiapan, on the strength of your word, just delivered you 5 million dirhams in cash?
Yes.
Okay, take that evidence. So you're aware
My lord, it's exactly the line of questioning I anticipated it was heading towards, and that's what we focused on nearly the entirety of the cross-examination.
Well, I'm inclined to let Mr. Prasivka ask his questions, and whether it has any relevance at the end of the day, I've made it quite plain that I think there's no relevance in this.
Yes.
I'm much more interested in the wording at the under the in witness part of the loan agreement, the manuscript that appears. But no doubt someone will come to that in due course.
Yes. Can I just take instructions from my client just for one moment?
Yes.
So I want to now just to move on to the issue of dishonesty. You're obviously in open court today. This is being recorded.
Mr. Prasivka, are you going to take up my invitation in relation to the wording that's in manuscript I'm looking at, as it happens, at page 190, but it's on the last page of the loan agreement.
Let me just see, 190.
Yes, the made in 3 copies, 1 copy to the lender, 1 copy to the borrower, and 1 copy to the lender's principal. No one has focused on that at all as yet, but it seems to me to be a highly material point in this context.
So do you have page 190 of the agreement?
Yes.
So did you deliver a copy of this agreement to Mr. Kachiapan?
Yes, I had offered this to Mr. Kachiapan, and he asked me to keep it in my safe custody, which is still with me.
And you still have a copy? So you never actually delivered it to Mr. Kachiapan?
No, Mr. Kachiapan tells me what to do, and I just follow his instruction.
Okay, I'll take that. So just to move on from this document, we're obviously now in open court. You're here, my colleague, my client is here. Do you believe that my client is honest?
It's an hypothetical question, very difficult to answer,
So you think he is honest?
depending in what sense you're asking.
Well, it's a general statement.
Well, I'm unable to answer this question because it doesn't very clearly ask. It's a very broad question that could mean anything and everything.
But you would not allege that my client has committed a fraud against you, correct?
As of now, yes.
As of now, sorry, say it again. So you would allege or would not allege he's committed fraud against you?
Yes. The day he refused, that he took the money, and that day itself, I feel he committed the fraud.
So your evidence is my client is fraudulent.
Can you repeat it?
Your evidence, I want to get a clear answer, and I appreciate yes or no. Your evidence is my client is fraudulent.
Yes.
And your evidence, I think, is that the very first time he was fraudulent was just in May of this year.
Last year.
Sorry, May of 2025, correct? So that's your full evidence.
Yes, that is the first time he refused. He denied ever taking the money.
And he never provided a security check to you pursuant to the agreement, correct?
The day when the money was delivered, he first looked at his checkbook. There were no leaves. He said the next day he would give it to me, and after that I followed up for a couple of days. I never got it, even though I was a bit worried, but that time he came across as very genuine, so I stopped bothering about the security check.
So you didn't think he was fraudulent at the time the agreement was signed?
No.
And my client never then gave you any information about the investments, correct?
There were verbal information that were shared. Once he shared that he made about 90,000 profit in one of the land deals. He gave me another figure of something like about 37,000 on the other one. But there were no evidential proof that I have seen.
So he never delivered statements to you in accordance with the agreement?
I have asked him multiple times, but he never gave it to me.
Can I now draw your attention to some of the WhatsApp communications between you? Could I draw your attention to page 315 of the bundle? And actually, could I start on page 314 of the bundle? And down towards the bottom. So, as of the 15th of June 2017, it seems to me that you were exploring the sale of land in Al Wasl. Is that correct?
Yes. He was talking about a land that one of his client had.
And so you were still dealing with him at this time? You still had good relations at the time?
Yes, I did.
And between December 2014, when the agreement was signed, and then between a demand that was issued in May 2017, you never once in writing demanded any further information about the loan, correct?
Can you be more specific?
Did you send my client a WhatsApp message, for example, saying, Mr. Ahmed, please tell me what you have done with my 5 million dirhams?
I pretty much used to meet him at least once in 2 weeks, so it was always a verbal discussion that has happened, or he would give me a call, or I would give him a call.
So
He wasn't much of a man to basically reply back in WhatsApp.
But you did send him a lot of voice notes on WhatsApp over the years.
I've sent him a
correct?
number of voice notes. Half the time he replies, half the time he doesn't reply.
So the very first time you ever made a demand, I think, was on the 28th of May 2017, correct?
It was actually much before that, but it was verbal. We told him that we wanted to exit the investment, and he kept giving us promises saying that the money would come, money would come, money would come. When it didn't come, then I started pursuing the legal process of giving a return.
And that was only in May 2017?
Yes, that is right.
So to look now just at the WhatsApp correspondence, so as of 2017, you're still pursuing other deals with my client, correct?
I do not understand. What do you mean by other deals?
Well, you say, quote unquote, I need a price for the Al Wasl land. And then my client states 900 dirhams. So this is nothing to do with the money that was advanced.
No, basically his client had the land, and he was asking me, if you know anybody, get this land sold, I can settle your loan immediately.
And so this is, you are corresponding sort of about the 5 million here. You're saying that the Al Wasl land was part of the 5 million.
Yeah, but there has been a side by side, there has been verbal discussions that were going on in terms of return of the 5 million.
So just to be very clear, your evidence here, as of the 15th of June 2017, is effectively you are discussing the 5 million loan. This is all in a wider context of potentially repaying the loan.
Yes.
And so this is why you refer to Al Wasl land. Could I ask you to go to the next page, and then at page 315 of the bundle. You go on to say then they are talking 25 million. So this is reference to another parcel of land, correct?
It's the same property which I went and informed to another person who was dealing in real estate, and the real estate gentleman came back with a figure, and that is a figure what I gave him.
So, but all of this is part of the overall 5 million loan. It's
He had to
effectively-
recover my 5 million loan, the cash loan that I had given him.
Okay. Then just to move on then, so in that same context, you say on the 21st of July 2017, can I collect the cash from you tomorrow? Do you see that?
Yes, he said that he's coming across some money, and he would give me at least the first payment.
And just to confirm, again, this is all in the context of the 2014 loan.
Yes, that is right.
So then you go on to say on the 21st of July 2017, by trusting you, I am losing everything I have. Am I correct in saying that you did not trust my client as of the 21st of July 2017?
Your question is very ambiguous. Can you be more specific?
You were questioning my client's honesty in that text message. You were doubting the money would ever be returned, correct?
He has been giving me promises after promises, and I have been getting pressure from my friend as to when the money is going to be returned.
Yes.
So it was a message out of frustration that after promising me so many times, he did not repay me the money.
Yes. So you, just to repeat your evidence, so as of 2017, you're corresponding with my client about the 5 million loan. You're questioning my client's honesty, correct? But by trusting you, I'm losing everything I have.
If you were in my position, wouldn't you?
Yes, exactly. I think I would. And then, of course, you never received the security check, and you never received the statements you were supposed to.
Yes.
So I think, as of that time, you were definitely suspecting that my client had committed fraud, correct?
I did not, because every time this discussion used to happen, he would promise me that definitely the money would be returned.
And you go on then to say you have been saying the same thing for the last 2 years. That's your evidence, correct?
Yes, that is right. That is, that, as I mentioned earlier, it's much before that we had asked him to dilute the investment and return the money.
And then you go on to say what you are doing to me and my family is not correct at all.
Yes, because I used to keep getting calls late in the night every day, and my family used to be disturbed by the calls.
So I think if I were in your position, and if we accept your evidence for the purpose of this question, I think I would not trust my client, and I would suspect at this point he's dealing in fraud. Is that correct characterization?
I was hoping at least some way or the other he would repay me the money.
Okay, thank you. Could we now just then turn to page 318 of the bundle? And I should just emphasize that it seems to me between page 315, 316, and 318, there seems to be effectively conversations about other business dealings. Is that a fair characterization? Or is all of this on your evidence between 315 and 317, is this all to do with the 5 million agreement?
No, there was some personal work that he wanted me to do at his wife's villa, which we undertook. And as you may see, the company bank details are given. It's clearly a commercial deal that we did for him.
Yes. Was this to do with the installation of doors?
Yeah, that's right.
Could I just flag to the court, just so the court has this? I'll find the pictures of the doors.
I've seen them elsewhere.
You see the pictures of
Don't
the doors,
worry.
but again, it's clearly referring to a different agreement. So now I want to go to the 30th of August 2018. And you go on to say, I swear Allah won't forgive you for what my family is going through because of you. Your evidence is that is also referring to the 5 million outstanding loan, correct?
Yes.
And then you go on to say, you have been giving me nothing but false promises.
Yes.
So this is 1 year after all of the correspondence we just went through. You're again saying effectively that you don't trust my client. You use the word false, correct?
Yeah, the promises, whatever he made, he didn't honor it. So obviously it is false. But I didn't say fraud, but I said false.
You said false. Can we now go on then to the 27th of March 2019? You go on to say, you promised to pay AED 25,000 out of the 5 million dirhams given to you as a loan almost 6 weeks back, and you keep giving me some or the other excuses. It has been over 4 years since I think I've made verbal requests and written requests, over 2 years back, and you have not paid me neither the profits or the principal or given me a statement as to where the funds are. So again, this is part of the same course of dealing. I think reading this text messages, I wouldn't think that my client is trustworthy. Is that a fair characterization?
It's not about trustworthy or not trustworthy. It's about asking my money back. That is what I have been doing.
Okay.
I'm not trying to make judgments here.
No further questions.
Thank you very much. Any re-examination?
Very briefly, Mr. Karthi, could I please take you to page 190? This was a document you were taking a moment ago. This is the agreement, the final page of the agreement.
Yes.
Firstly, the handwritten writing where it says made in 3 copies, 1 copy to the lender, 1 copy to the borrower, and 1 copy to the lender's principal.
Yeah.
Whose handwriting is that?
Yeah, it's my handwriting.
Yours, okay. And who asked, why 3 copies? Whose suggestion
Because
was that?
one, I kept it with me. One, I gave it to Mr. Almala. One, I wanted to keep one for Mr. Yuvraj Kachiappan, just to make sure that, whatever dealing that has happened is straight, clear, and honest.
So it was your idea, is that right?
Yes.
Thank you. I have no further questions.
Thank you very much, Mr. Karthi. Those are all the questions for you. You are now released from the witness box and free to come or go as you would wish.
Thank you.
And the second witness is Mrs. Kavita, the claimant's wife.
Yes, very good.
I understand she's not available. I understand.
So she will come on the time in the timetable. She thought that's.
Oh,
Yeah.
I see. We're well ahead of our schedule.
Yes. Is she not? Is she planning to come for a later time? Is that what I'm understanding?
We can
I think she's going to be there at 1:30 at Dubai time.
Which is another hour.
Yes, because she was due to give evidence at 2:35. She was going to come 1 hour before she was due to give evidence. I can make some inquiries to see if she can arrive earlier.
Well, I think that would be sensible, don't you? We don't want to simply waste time. Where are we? We're now 12:30 Dubai time, right?
Yes.
And she's
That's right.
currently not expected for another hour. Is that right?
That's right. Yes.
Do you think someone could make a call?
Yes.
I'll adjourn for 5 minutes whilst you make the call, and then you let me know what the position is.
Yes. So those instructing me suggest she could be here in 30 minutes, but they'll make some inquiries to confirm that.
All right. Is there any other way we can sensibly use the interim period?
I don't believe so. No. What I'd suggest is we reconvene in 30 minutes, or well, exactly on the hour.
The only
And
Mr. Jarman could give evidence for my client. I think he'll be quite a short witness, but obviously I'm in my colleague's hands.
I would much prefer concluding the claimant's evidence before we go to the defendant's witness.
All right. Well, in which case, we'll take half an hour's break now. That's we're 12:30 Dubai time, so I suppose it's quite convenient for Dubai to take lunch at this point. I'll have a cup of coffee, and we'll convene again on the hour in the hope that she's available at that point, and then we'll decide how matters proceed thereafter. All right. So I'll adjourn now until the hour, 1 o'clock Dubai time, 10 o'clock London time. All right. Thank you very much indeed.
Apologies, my team is just coming in now.
That's all right, Mr. Pacifica. Don't worry. The most important thing is, do we have the witness?
We do, yes.
We do.
Very good.
Yeah, I think the witness could go into the witness box.
Please confirm your full name and occupation for the court's record.
My name is Kavita Balasubramaniam. I'm managing partner for Ahmed Technical Services with Karthi, Keyan, Venkataramana.
Thank you. Will you be swearing in by oath or by affirmation?
I can swear by oath.
Okay. Can you please confirm your full name?
Geeta.
Can I just say before the witness is sworn in that I'm not getting a very full picture of the witness. I'm getting a very small picture at the top of my screen. Is it possible that we can have a focus on the witness?
Yes, Your Honor.
Yeah, we're still fairly small.
It's the same for me.
What I'm getting, that's a bit more like it. Yes, all right. I think we can live with that. Yes, so could the witness be sworn, please? Thank you very much.
Please repeat after me. I swear by Almighty God
I swear by Almighty God
to say nothing but the truth.
to say nothing but the truth.
Thank you. Mr. Sullivan, will you just ask the witness to confirm her witness statement?
Yes, Mrs. Kavita, could I please ask you to turn to page 119?
Yes, we've done.
This says the first witness statement of Mrs. Kavita, and then page 121. Can you confirm that is your signature?
Yes, that is.
And do you stand by that statement and the accuracy of that statement?
Yes, absolutely.
Thank you.
Yes, Mr. Pacifica.
Thank you very much. I don't intend to be very long, and again, I don't intend to be very confrontational. So just to confirm, your evidence is that you witnessed the signing of the documents on the 11th of December 2014, correct?
That's correct.
And your further evidence is you didn't actually see any cash being handed over then.
No.
So what I want you just to do for me is I'd like you just to tell me about the course of the day. So you got up in the morning. What time roughly did this meeting take place at?
I don't exactly remember the time, but it was sometime in the afternoon, and it was usually always it's midday during a little early afternoon. We went to Mr. Almullah's office, and there was a signature, a contract that needed to be signed for the money that was supposed to be given to him. We normally go, me and my partner, we normally go together to his office for any...
Your partner being your husband? Or...
Yes. So we're also business partners. So we go together and to talk about any dealings or any procedures. We went that day and we went to his office. The signature happened. I signed as a witness and then I left. I believe the money was exchanged later, but I wasn't present for it.
Okay, so where did you leave when you left?
I went back to the office.
Back to
my office, yes.
To your office. Where is your office?
Al-Quds.
Al-Quds.
Yeah.
Because you're aware your husband gave it evidence that you went back home to Barsha.
It depends whether, if it's a pickup time for my daughter, then I would have picked her and gone home. But I can't remember the exact timeline.
So, sorry, your evidence is now that you picked up your daughter?
I don't know. I can't remember.
Okay. So you never saw any cash being handed over?
Not at all.
And just being in open court now, is it common for your husband to keep large amounts of cash in your house?
I'm not familiar with that.
So would you be surprised to learn that for your husband to state that, I think he stated to us that he had 5 million dirhams in cash in your house?
I don't know. I don't usually get involved in financial dealings.
I thought you said yourself and your husband were business partners.
Yes, but I look after the business, not personal.
Not personal. So you had no knowledge whatsoever of the content of this deal?
I know what the deal meant, but I didn't get myself involved in exchanging of cash.
Okay, and so you weren't there when the cash was exchanged?
I didn't go there when the cash was exchanged.
So you went to your office in Al-Quds directly afterwards?
I can't remember whether I went to Al-Quds or Barsha. It's fairly close by. So I don't have recollection of where exactly I went that day.
And where's your daughter's school?
It's in Barsha.
Barsha. So
yeah.
Your evidence is, so if you don't know, you don't know.
I don't know. I can't remember.
Because your husband said very clearly you went back to collect your daughter.
It's possible he has a better memory than me.
And then your husband's evidence, I think, was very clearly is that you went back to Barsha, you collected your daughter, your husband went to the house. Your husband then collected 5 million dirhams in cash. And then he brought the money back to Dira.
Well, he did say that he is going to go and give the cash later on. That's all I know. I don't know when and how.
Okay, and so just where in your house do you think would 5 million dirhams in cash be stored?
I don't know. I don't look at where, I don't know where he keeps the money.
But so are you surprised to learn that your husband was storing 5 million dirhams in cash in his house? Or is that just a normal...
No, I know that this was to happen, so I won't be surprised if that was there.
Perfect. And so you never saw the rucksack with the cash?
Well, it is my rucksack. I learned that he gave my rucksack away. It's a very personal there's a personal element. I had a go at him that he left his rucksack there because it was my first, it was a JanSport rucksack that I bought initially when I was in the UK. So I was a little pissed at him that he gave my bag away. But other than that, I didn't know where he was. I didn't know about whether he had it in that bag or not.
So your evidence is your husband used your bag to store the cash.
Yeah, we had a number of rucksacks.
Number.
He just picked up one, so.
He's picked up one, and
Yeah.
he brought it then back to Dira.
Well, of course, we had to go and give the cash always, so I'm not surprised that he would have gone and given it back to him
And
then.
did you have a driver who did this?
No.
So you drove yourselves.
Yeah,
Who drove?
he drives.
He drives.
Yeah.
So just to get the timeline correct, he drove. You both were in Barsha. On your evidence, you went to Dira. Then your husband potentially dropped you back to Al Quoz, but it could have been Barsha, and it also could have been to collect your daughter.
It could have been, yes.
And then I think you don't know what happened next, but your husband's evidence, I think, is that he went and he collected the cash from Barsha and brought it back to Dira.
Well, yeah,
And do you think you could do all of that within an hour?
he would.
You would?
Yeah.
Okay. I have no further questions for the witness.
Any re-examination?
No re-examination, thank you.
Thank you very much, Mrs. Kavita. We're very grateful to you for coming.
Thank you.
You're free to come and go as you would wish.
Thank you.
Sorry to have inconvenienced you by asking you to come earlier than you were otherwise expecting, but thank you very much.
Thank you.
For our witness, if we're to go into evidence, he requires an interpreter. My understanding is the interpreter was due to be here in 2 minutes. Sorry, 2 o'clock, sorry. What we could potentially do now is Mr. J. Arman could go into evidence as of right now. I don't believe he'll be a very long witness. If that suits, my apologies for bringing this up at the last minute.
Mr. Sullivan?
Again, not ideal. I think in order of it would be helpful to have Mr. Ahmed first, actually. But we're in a difficult position. I don't also want to lose another 30 minutes.
Well, I think you need to make a decision about that, Mr.
Yes.
Sullivan.
If I may just very quickly take instructions.
Yes, of course.
Yes, okay. Yes, we'll proceed with the next witness.
Right, well, let's have Mr. Sullivan then. Mr. J. Rahman. Prakash.
Can you please confirm your full name and occupation for the court's record?
My name is Prakash Jayaraman. I'm basically a travel and tours consultant in Dubai, before that in India.
Thank you. Please place your hand on the holy book and repeat after me. I swear by Almighty God.
I swear by Almighty God to say nothing but the truth.
Hey, Mr. J. Rahman, thank you very much for coming. Do you have a copy of the bundle in front of you? I think the hard copy is the easiest thing to use.
This one? Yeah.
Yes. Could you open that to page 122, please?
Yes.
Could you confirm that this is the first page of your witness statement?
Yes, it is.
And could you confirm on the following page that you made that is your signature?
Yes, it
And
is.
could you confirm that you stand by the contents of this witness statement?
Yes.
Thank you very much. My colleague will ask you questions.
You're muted, Mr. Sullivan.
This one?
My apologies, that's inevitable during the course of the day. If I may start, please, with page 254.
Yes.
You can confirm that is Prakash is you, and that's your signature, yes?
Sorry?
That is your signature
Yes, it is.
on the page.
Yes.
And did you witness the other individuals signing that document in front of you?
Sorry, can you come again?
Did you see the other people, the other signatures we see on that page? Did you see
Yes,
those?
yes.
You watched them as they signed it?
Sorry, I'm sorry.
Can I? Well, I won't. I understand it's not in dispute. You did witness, so you did see when you signed this document. You saw Mr. Ahmed sign the document.
Yes,
You did.
yes.
And did you see Mr. Ahmed sign every page of the document?
I'm not too sure about it. Whether I was just told to sign the contract of the page, having known Mr. Ahmed because he also happened to be the sponsor of my travel agency, and I know him for the past 30 years in Dubai. So I just signed the contract. Obviously, you know, it is the last 35 years I know him being my sponsor. That's it. I didn't go through the contents of the other pages.
I see. So if we look over the page, one page up, 253. So you can't confirm whether that was signed by Mr. Ahmed.
Uh, 253, yeah.
So that document you can't confirm. You can't confirm or deny. You didn't see whether it was signed.
I can't confirm. As I said, I just only saw the last page and I just signed it.
Okay. And so page 255, I think I know what your answer is, but I'll ask you anyway. Page 255, you don't know whether Mr. Ahmed signed that or not.
No.
Yes, you didn't see that document.
No.
If we have a look
Yeah.
at page 259. Again, I think I know your answer, but you didn't see Mr. Ahmed sign that.
No.
You don't know whether he did.
No.
Okay. And finally, page 265, please. And again, I think I know your answer, but you didn't see Mr. Ahmed sign that. You don't know whether or not he signed it. Okay, thank you. Briefly on your relationship with Mr. Ahmed, you said he's been your sponsor for some 30 years, 35 years?
Yes, I know him actually for the last 35 years because I used to handle for one of his group of companies, the travel and tourism, you know. So it was somewhere around 2012 or 13, I decided to start my own business. So I just went to Ahmed and I casually told him that, you know, I want to start my own travel agency business. So he said, okay, be my sponsor, no issues. I'll be your sponsor. And then he just got it done. That's how it started, the whole thing.
And what year was that? 2013, did you say?
Yeah, around 2013, and officially the license I got it in 2014. Since that time, he has been my sponsor for my travel agent till date.
And it was in 2014 that you made the introduction.
No, the introduction
yes,
for the opening of the agency, but I know him before that itself. You know, I mean, from 1986. 86, 87 was the time when I came to Dubai, and as I told you before, I was handling the corporate travel for one of the companies, Mustafa bin Abdul Latif. That's how I came in touch with him that time, you know.
My question is focusing on your introduction of Mr. Karthi to Mr. Ahmed.
Yes.
Did that happen in 2000? That happened in 2014. Is that right?
It happened, yes, because obviously I knew Karthik through a family friend of mine, and I was introduced to him, and then he was looking for a sponsor for for his company, So I said that, okay, well, I can introduce you to my sponsor, whom I know for so many years. Then I introduced him.
And we saw the documents we looked at, the one you signed and the other individual signed, that's from
Yes. Before
11th,
that, yeah.
11th of December 2014.
Yeah.
Do you recall approximately how many months before that did you make the introduction to Mr. Karthi?
No, I don't really remember.
Are we speaking weeks or months?
Oh, I really don't remember. It's only that, as I told you, that I was introduced to him by a family friend of mine, who also happens to be his wife, Kavita. I know her. So through her, it was introduced, and then they came that they wanted to start their own business. So that's how it happened.
Okay, but it was just the dates are somewhat important, but it was in 2014 that you made the introduction.
As I said, that I'm not too sure about it. That I don't remember when the introduction was exactly, the timing.
Okay. Well, and I'll conclude this line of questioning here. So in your witness statement, page 123 of the bundle.
16?
123, please.
1, 2, 3.
Paragraph 4 of your witness statement. So when you say you made the introduction in 2012, it says in 2012 I introduced the claimant.
That's why.
And this might be a typo. I want to be clear about this.
Yeah.
That's incorrect, is it? 2012 is incorrect. You made the introduction in 2014.
Yeah. No, see, as I told you that I know his wife before, and then he was introduced. As I said, I don't remember exactly the date on which yes, of course, I do stand by what I mentioned, that I introduced the client to the defendant, possibly,
Okay. And my final question is that at the meeting with the documents we looked at on the 11th of December, at that meeting, how long were you there?
I was there to sign the contract. I just signed the contract and then I just left.
And did you speak to either Mr. Karthi or Mr. Ahmed after signing the contract?
No, because I had my own work after that. I just left that because it is not my part to know exactly what is going to happen and all. I just came there, signed the contract. But yes, I do know that, the Karthi had mentioned that he was planning to do some business with him. So I said that, basically I introduced him. Now the ball is in his court, that what he wants to do.
And after that date, after 11th of December, when did you next speak to either Mr. Karthi or Mr. Ahmed?
Karthik, after that, I have been talking, I have been going, obviously, as I said, that Kavita is a very close family friend of ours. I used to go to his house regularly for the social, some functions, everything.
And after that date, after 11th of December, when Mr. Karthi said to you that Mr. Ahmed is not giving back my money, what did you say?
No, I told him that it is not my cup of tea as to what it is, because I don't like to interfere, he only being my sponsor for me and for him, because my job is to sell tickets and send people on tours.
Did you express any view on how the money could be recovered?
No.
How the 5 million?
No.
Did you know anything about the investments that were going to be made with the money?
No.
Did Mr. Ahmed speak to you about the money?
No.
Are you sure about that?
Yes. Ahmed, of course, did tell me that, they are planning to do something. I said, okay, fine, good luck.
And in the years that followed, I can't be more precise than this. In the years that followed after 2014, so around 2017 and 18, did you know what was happening between Mr. Karthi and Mr. Ahmed in terms of their business dealings?
I'm sorry, I could not understand.
Did you know whether they were still in business together at that time?
Yes, they were in business. Yeah.
Did you know that Mr. Karthi was still asking for his money back?
You mean ask me?
Asking Mr. Ahmed for his
No,
money.
I again told him the same thing. I got nothing to do with that. Whatever it is between him and this thing. But I exactly don't know what that, basically the transaction that is happening or what business it is and all those things. But yes, did Karthik did mention to me once that, they are trying to find some land or something. That's it.
Okay. When did Mr. Karthi tell you that? When they were trying to find land?
Sorry, come again?
Approximately what year even? What year did Mr. Karthi tell you they were still trying to find
So
land?
around 2017, 2018.
He told you they were still trying to find land.
Yeah.
And did you understand that was in relation to the 5 million dirhams?
No. I didn't understand on what kind of, for what transaction it was and all.
Okay, thank you. I have no further questions.
Thank you. Any re-examination?
Just one very quick question. So you were at the meeting on the 11th of December 2014.
Yes.
Your evidence is you weren't at the subsequent meeting an hour later.
Right.
At the meeting, did the parties, to your knowledge, discuss at all the handing over of cash at all? Or did?
No.
Perfect.
No.
Thank you.
Thank you very much. Those are all the questions for you. Thank you for coming, and you're free to go.
Unfortunately, the interpreter is still not here. She in all fairness, we had said 2 p.m. and we'd had asked her to come a little bit earlier, but she's still not here. She should be here imminently.
So what do you want to do, Mr.
Could
Pacific?
I propose to take a 15-minute adjournment?
Okay. Shall we say on the hour again?
Yes, that would be very good. Thank you, Judge.
Very good. We'll adjourn and recommence on the hour. Mr. Suleiman, do you have any idea how long you might be with the witness?
30 minutes is what I
right.
expect.
Okay. So if we finish the witness in that sort of timescale, let's err on the safe side and say 3/4 of an hour or something. Is the plan then simply to adjourn until tomorrow for closing speeches, or how do you want to deal with it?
Yes, I think I would propose that. I mean, perhaps we could certainly do closing speeches remotely, so we wouldn't necessarily all have to be back here tomorrow. In the alternative, I mean, I could give it closing now, but perhaps it's best to use the time overnight to
Well, I don't mind at all. If you're prepared to make your closing, why not get on with it?
Yes,
let's see where we get to after we've heard the evidence, and you can then let me know what you think is the most efficient way of proceeding.
Yes, thank you very much.
All right, we'll take a 1/4-hour adjournment now and recommence on the hour, please.
Thank you.
Right, are we all set to recommence?
Yes, we are.
Thank you. I'm going to first swear you in.
Okay.
Can you please confirm your full name
Nashwa Medhadzaki,
and your occupation?
interpreter.
Thank you. Please repeat after me. I swear by Almighty God
I swear by Almighty God
that I will interpret the evidence
that I'll interpret the evidence
that will be given
that will be given
to the best of my knowledge
to the best of my knowledge
and ability.
and ability.
Thank you. Please place your hand on the phone. Please ask him to repeat after you. I swear by Almighty
أحلف بالله
أحلف الله
God to say nothing.
أن لا أقول شيء غير الحق.
قال أقول أي شيء إلا حق.
Thank you.
Thank you very much. So, Mr. Ahmed, you do speak English, correct?
تتحدث الإنجليزية؟
لا ما أفهم شوي بس ما أفهم أحسن.
Well, we've spoken English before, the two of us.
Yeah, but I see when you're talking, I speak, I understand, but not what you want exactly. That I asking to bring the time.
Exactly. So could I ask you to turn to page 99 of the hearing note? And that's the first page of your witness statement. Could you confirm that that is your witness statement? And could you also then confirm on page
لازم تأكد لهم إن دي الإفادة بتاعتك وإن ده توقيعك.
ايوه ايوه صح صح.
Confirmed.
Now, could I ask you to turn to page 113 of the bundle? And again, this is the first page of your fourth witness statement, your second trial witness statement.
دي رابع إفادة.
نعم.
And could I ask you then to turn to page 118 of the bundle? And you confirm that that's your signature
نعم.
on the page.
نعم توقيع.
Do you confirm you stand by the content of both of those witness statements?
ملتزم بما جاء في الإفادة.
اي نعم.
Thank you very much.
May I begin my cross-examination?
Yes, I'm afraid I was having difficulty hearing Mr. Pasifka.
I think my microphone was not on. Apologies. It's now on.
All right. But has he confirmed his third, fourth, and fifth witness statements?
So just to clarify, there are two trial witness statements, but I think in the context of the proceedings, I think he's given at least 4 witness statements. So he's just confirmed his 2 trial witness statements, dated the 1st.
Which are the third and fourth?
Yes, which are the 3rd and 4th, I believe. Yes, they are the 3rd and 4th.
Yes, thank you. I wasn't quite clear about that, but thank you very much. Yes.
No. No.
All right. Well, there are going to be some further questions from Mr. Sullivan, Mr. Ali. When you're ready, Mr. Sullivan.
Thank you. Mr. Ali,
ما أنا جاهز. نعم. نعم. Yes.
could I please begin by asking you a little bit about yourself? If I understand correctly, you're a businessman and you act as a sponsor, as a local sponsor for various companies.
حضرتك رجل أعمال وعندك كفالة لأكثر من
نعم.
شركة.
نعم. نعم.
Yes.
And is there a particular sector that you specialize in?
في قطاع محدد متخصص فيه؟
لا ما في متخصص.
No.
Is it right that you are involved in real estate and land investments?
متخصص في العقارات والأراضي.
مش متخصص في العقارات، متخصص أنا جنرال أشتغل يعني، عرفت شلون؟ عامة أشتغل.
No.
يعني ما عندي خاص في العقارات
No,
يعني.
I'm not specialized in real estate or land. My specialization is just general and wide, general business. Is my voice going to?
Do you have?
Do I need a microphone?
I think you can be. Can the translator be heard? Just to confirm.
Okay.
I think the translator can be heard on screen. Yes, I think you can. Yes, thank you.
Yes, we can hear you. To be clear, Mr. Ali, do you have any experience or expertise in land and real estate investments?
لديك خبرة في العقارات والأراضي؟
لا أنا ما عندي خبرة، الخبرة خبرة بس أشتغل في العقارات يعني.
Not really an experience, but I have worked with
يعني
properties
أحصل
and
شيء
land.
أبيع وأشتري ما عندي مانع يعني.
If I find a good deal, I would buy and sell and work and have business in this sector, but it's not like a main specialization.
So when Mr. Karthi was going to give you 5 million dirhams to invest in land and real estate, what were you intending to do with that money?
طيب لما أقدم لك السيد كارثي ال5 مليون عشان تستثمر في الأراضي والعقارات، كانت نيتك إنك تعمل إيه بيهم؟
هو ما قدم لي 5 مليون.
He did not actually hand me 5 million dirhams.
My question is slightly different. My question is, when you were agreeing to receive 5 million from him, what were you intending to do with that money? Had you, I understand you say you didn't receive it. If you had received it, what would you have done with that money?
لما وافقت على الاتفاق إنك تستلم 5 مليون حتى لو ما كنتش استلمتهم، كانت نيتك تعمل بيهم إيه لو كان الاتفاق ده مشي؟
إذا حصلنا نشتري الشقة نشتري أي شيء ونبيع نشتري مع بعض يعني طرفين بس ما تمت يعني.
My intention was to look for good properties to buy and then sell and work together with him, but this did not go through.
Okay, if I could then take you, please, to the agreements. There's many copies, but I'll take you to the one at page 239, please. page 239. Once you're there, if you could let me know, please.
Yes.
Okay. Can you confirm that is your signature next to your name?
That okay?
أتوقع توقيع هنا.
Yes.
توقيع.
And at the bottom page, that is also your signature. You signed that.
توقيع.
Yes.
And if we go, I'm not going to go through every page, but it is signed on every page. And if we go then to page 241, please. This is again your signature at the bottom of the page.
Yes.
And if we look 3 paragraphs up from your signature, 3.1, subject to the terms and conditions set here forth, the borrower hereby agrees and acknowledges having received the loan of 5 million dirhams on the date of this agreement
طيب.
from the lender.
بيقول إنك استلمت بالفعل 5 مليون received
استلمته؟
أيوة.
وين مكتوب استلمت هذا؟
استلمت received.
إيه. لأن ما قريت الآن أنا ما كنت أعرف يعني ما كان عندي دراية بالإنجليزي عشان أنا وقعت أنا صراحة وقعت ما أقول لك ما وقعت أنا بس ما استلمت فلوس يعني. أنا وقعت بس ما استلمت فلوس.
I confirm this is my signature. I have signed the agreement, but I'm not I'm not fluent in English, and I did not read and understand this
وما
point.
استلمت.
So I did not receive actually the 5 million that are stated here.
Did you read this page before you signed it?
قريت الصفحة دي خالص قبل ما
لا ما أنا ما أفهم شوي بس ما.
No, I didn't because I'm not very fluent in English language. So I did not read the whole agreement, actually, not only this page. None of it I have read.
None of it? Just to be clear, you didn't read any of this?
ولا أي حاجة من الاتفاق.
Is that right?
ما حد قرأ.
ما قريتش ولا حاجة من الاتفاق كله.
لا ما قريتها.
No, none of it.
And so if I please take you to page, the promissory note, page 255, please.
Yes.
You didn't read this document before signing it either? Is that right?
ده توقيعك؟
نعم.
ما قريتش دي قبل ما
ما
توقعها؟
قريتها.
No.
And then if we go on to page 259, please. Can you see where it says amount paid 5 million dirhams and then you've signed that?
مكتوب هنا 5 مليون مدفوعة وتوقيعك.
نعم. هذا التوقيع احتمال توقيع احتمال مو توقيع بس توقيع توقع يعني توقيع أنا. نعم توقيع. أنا ما أقول مو توقيع توقيع بس أنا ما استلم شيء يعني.
Okay. It is my signature, but I did not get this money.
But did you read that where it says amount paid? And I appreciate your English, you said is not fluent. But we've seen your WhatsApp messages. You have some English.
No, I haven't read that.
Yes. Did you understand what amount paid means?
الكلمة دي مش عارفها. Amount
paid. أنا أقول لك أنا كلها أنا ما قريتها كلها.
No, I did not read it.
What did you think was...
ما أدري إذا بكرة لو قريته هو أخذ العقود وراح. أخذ العقد وراح.
ما كانش عندك وقت يعني.
لا ما كان في فلوس أصلا ما في فلوس. أخذ العقد وراح عشان يرجع مع هذا.
So he's saying that he took all the documents, the contract and the agreement and left without handing.
ما رجع مع الفلوس يعني.
Without to be back with the money, but he wasn't back with the money. He did not return with the money.
I see. And so where did you think he was going to get the money from? From his house?
المفروض كان هتاخد الفلوس فين؟
المفروض يجيب فلوس عندي.
فين؟
المكتب.
المكتب. He was supposed to bring this amount to my office.
And you were waiting.
وقعدت تستنى؟
أنا موجود الساعة 5:30 كنت موجود بالمكتب.
I was there until 5:30.
أنا مكتبنا نسكر الساعة 5:30. ويلا.
We close at 5:30 every day.
Did he tell you, did Mr. Karthi tell you he was going to come back?
هو قال لك أنا هرجع بالفلوس؟
نعم.
Yes, he did.
Did he tell you he had the cash at home and that's where he was going to go?
قال لك هجيب الفلوس منين من البيت؟
ما ادري
ما قال لك.
ما قال لي، ما قال انا مع فلوس، لان انا اللي ثقت فيها كنت شريك معاه. انا كفلت لله، يعني ما كفلت يعني. يعني انا كفالتي لان جاء عن طريق واحد اعرفها من 30 سنه، فانا كفاله كنت وياه بالشركه مع بعض. شركه ثانيه غير هذا.
Okay. He did not specify where the cash
صدقت
is.
يعني صدقته.
And I trusted him on everything blindly because I was his sponsor, he was my partner, I knew someone who knew him for 30 years, so I trusted him blindly. He did not specify where the cash was.
And what was the plan? So your understanding, so he was going to bring the cash to you and then what would you have done with the cash?
طيب لو كان رجع بالفلوس كنت هتعمل ايه بقى بعدها؟
لو كان رجع بالفلوس كان سوينا شيء، شرينا شيء، على الاقل يبين ان احنا شارين شيء ولا مو شارين شيء. هل شيء كان داية الاراضي، هل انا شريت شيء؟ ابدا ولا شريت شيء ولا شيء من طريق اليوم كذا.
I would have used.
هل انا شريت الفترة هذه شريت شيء؟ لا ابدا.
اخر حاجة؟
تفضلي.
اخر حاجة قلتها؟
يعني ما شريت شيء يعني من عطى، يعني لو انا شاري شيء يبين ان انا شاري شيء.
Okay. So I would have invested this amount in buying and selling properties, but you can check through.
لو كنت مستلمت.
If I would have got this amount, I would have invested it to buy and sell properties, but I haven't got the money, and you can check with the land department if I have bought anything since that date to now.
What is I'm trying to understand the process. When you receive, if this happened, you were going to receive £5 million in cash, how would you have gone and then purchased land exactly? You would put it into your bank first and then you buy land? Was that what you were planning to do?
هو عايزك تتخيل انك لو كنت خدت الفلوس دي كانت ايه بالظبط الخطوات اللي هتعملها؟ هتحط الفلوس في البنك الاول
لا
ولا
ما بحط الفلوس
ولا هتعمل ايه بالظبط؟
اكيد انا اول شيء انا اعطاها للمصدر الفلوس. انا ما قلت له شيء. انا قلت له جاني فلوس اقول له من وين الفلوس هذا، لان هنا في دبي يسالون الفلوس هاي من وين. ما جاني فلوس عشان انا ادخله في حسابي. ما جاني فلوس.
ايوه لو كانت جات.
لو كان جاي انا دخلت فلوس قبل لا ادخل في حسابي من وين وصل الفلوس، لان هنا بيسالون من وين الفلوس. انت لو توديه اي مبلغ للبنك يقولون ما وين ما الكلام هذا.
ايوه بس هو عايز يعرف كنت هتعمل ايه الخطوات.
نشتري فيه شيء بموافقته.
لا الخطوات التفاصيل.
الخطوات لو كان جاي بنحطه وبنشوف شنو موجود.
هتحطها في البنك الاول.
اكيد في البنك احطها. وين احطها؟ بالبيت اكيد. ما احط فلوس في البيت.
So if he would have given me this amount, I would have needed to know the source of the money because I will not be able to deposit it in my bank account if I do not give the bank a clear statement about the source of this amount of money. And then after depositing it to my account, I would have started looking for good properties to invest in, but I did not get the money, so I did not do that. My intention was to first investigate or ask him about the source of the money and then deposit it to my account. That would have been the first step.
But Mr. Ali, you told us a moment ago that you were waiting for him to bring the cash. He had gone and you were waiting and he never came.
بس انت قلت انك استنيته يرجع وما رجعش.
ما رجع.
Yes, true.
And by this point you've already signed the agreements, yes?
يعني انت وقعت الاول قبل ما
استلم.
Yes.
بعدين هو جاء مع زوجته زين. وما كان اللي هو عارفه انا بركاش من 30 سنه، عارفه يمكن اكثر من 30 سنه زين. كانوا موجودين خذوا وروحوا. يعني اول شيء بركاش راح، انا اتذكر هالشيء هذا. بعدين هو يا زوجته خذوا العقود وروحوا. ما جو انا بعد صراحه اقول لك ما اهتم، يعني ما اهتم الا لما طلعت من الشركه يا القضيه هذا جاب لي العقود قال انت ماخذ فلوس من عندي وانا تفاجات.
Okay, so more details. He was there with his wife at the time this agreement was signed, and Mr. Prakash, and then Mr. Prakash left first, and then the claimant left with his wife and the contracts and everything on the basis that he will bring the money and come back. And he didn't. I forgot all about it until I left the company, and then he came back with this case saying that you have taken money from me.
أنا تفاجأت بعد فترة أنا بس أبي أغير كفيلي قلت له غير ما عندي مشكلة أنا لأن أنا مش عرفت غير كفيلة بعد ما غير كفيلة يا سوى شيء هذا.
And also he came at a certain point before confronting me with this agreement or the case at all, he came and said that he wants to change his sponsor and that he will have a different sponsor, and I just told him you can go forward with that. After he did that step, he came back with this agreement saying that you owe me money.
Mr. Ali, I want to go back to the 11th of December 2014. When you had already signed the contracts and Mr. Karthi had gone to collect the cash, you were waiting, your evidence was that you were waiting for him to bring the cash to you.
Okay.
You were not at this point going to carry out any verification of source of funds.
Sorry, can you repeat the question, please?
At this point, when you were waiting for the cash to arrive, you said you're waiting in the office, Mr. Karthi's gone to collect the cash. You have already signed the agreements at this point. It's simply not true that you were going to check the source of the funds. When Mr. Karthi was going to bring 5 million dirhams in cash to your office, you were at that point going to check the source. That's inconceivable, isn't it?
كنت هتتحقق من مصدر الفلوس لما يرجع ويجيب الفلوس يوم 11 سبتمبر 2014. لما يرجع بالفلوس كنت هتبدأ تتحقق من مصدره.
لأن أنا قاعد قدامك أي مبلغ أوديه البنك.
أيوة.
يسألوني من وين. وبين أنا أمثل ناس يعني ما لي شغل أنا مثلا أي مستعر فلوس مبلغ كبير يقولون لك من وين هذا. يعني أنا ما أقدر أخذ 5 ملايين أخش عندي لين أدور على شيء أكيد أدخله في الحساب والحساب يقول لك من وين المصدر هذا من وين الفلوس يعني ما لي شغل فيه.
I would have investigated the source of the money because by law in the UAE I wouldn't have been able to deposit it to my account if I don't give them a statement about the source of this money.
Could I please take you to your witness statement, page 100 of the bundle, please? Page 100, paragraph 4, please. Now, the second sentence, you said, therefore, no investment took place. The third sentence, I further confirm that I would not have accepted such a large sum of money in cash. But it turns out your evidence today is you were sat there waiting for this large sum of money in cash for Mr. Karthi.
طيب هنا دي إفادتك. دي إفادتك.
أيوة.
إفادتك أنت. هنا أنت قلت أنا مستحيل أقبل مبلغ زي ده كاش.
إيه ما أقبل. لو يا بقيت بقول له وين مصدره يعني أنا ما يا بالكاش قلت لك أنا قاعد أكرر يعني ما بقبل أو إذا قبلت بقول له وين مصدرك.
Okay. What I meant here is that if he would have brought this amount in cash, I wouldn't have accepted it before knowing the source of it with documentation.
But Mr. Ali, why didn't you say that in your witness statement? You provide several witness statements. At no point do you say that.
طيب ليه ما ذكرتش موضوع التحقق من مصدر الأموال في أي إفادة من إفاداتك؟ لا ليه ما ذكرتش إنك كنت هتتحقق لو الفلوس كانت جات ما ذكرتش إنك كنت هتتحقق من مصدرها في أي إفادة؟
أكيد بتحقق 100% أي واحد.
أيوة هو بيسأل ليه ما ذكرتش ده في الإفادات؟
ما ذكرت يعني واحد ينسى يعني يتذكر وبعدين معروف أن في الإمارات يعني خاصة في الإمارات مصدر أكثر من 50,000 درهم حتى يقولون وين مصدرك؟ أكثر من 50 ها؟ حتى في المطار لو بتطلع أكثر من 50,000 درهم قولي لهم هذا اللي قاعد أقول لك مصدرها أكثر من 50 يقولون من وين؟ زين؟ ويسوي حساب بعدين لو حتى لو بتطلع برا الدولة من المطار يقولون لك أكثر من 50 يقول لك من وين هذا؟ من أين لك؟
Because I thought everyone knows that and I wasn't, my mind wasn't that present to mention that point in specific. And I thought everyone knows because by law in the UAE, You cannot have more than 50,000 dirhams to deposit in your account or to leave the country with it, except if you have a clear documentation of the source.
Mr. Ali, it's true, is it not, that you asked for the cash? Mr. Karthi went and collected the cash, and Mr. Karthi then handed you the cash.
انت طلبت منه يجيب لك كاش وهو راح عشان يجيب الكاش ورجع بيه؟
لا هو قال بيجيب فلوس ما قال كاش ولا ما كاش اخذ الاجريمنت وراح هو ما قال بيجيب كاش ولا انا طلبت
he did not specify in what
ولا انا
form.
طلبت منه قال بروح اجيب الفلوس.
I did not ask for a specific form of the money, and he did not specify how will the money be presented. He just left with the contract and said, I will come back with the money.
As we're on page 100, if we could have the very look at the very next paragraph, paragraph 5. A few months after signing the loan agreement, the claimant, Mr. Karthi, requested the partnership be terminated, and you agreed without objection, and then shortly thereafter, he found a new sponsor. So you said a few months after signing the contract. Are you aware of the approximate dates? Is this early 2025? Sorry, 2015?
طيب بالنسبة للنقطة دي إنه هو طلب منك إنه يفسخ الشراكة اللي بينكم. هنا أنت قلت كده إنه بعد أشهر من توقيع الاتفاق طلب
بعد
منك.
فترة بعد فترة.
مكتوب أشهر هنا.
إيه بس ما أتذكر يعني إيه فترة يعني ما أتذكر.
أوكي بس أكمل لك عشان لازم أقراها لك. بعد أشهر من توقيع الاتفاق طلب إنه يفسخ الشراكة اللي بينكم وأنت وافقت بدون أي اعتراض، وبعدها أصبح عنده كفيل جديد.
كفيل جديد.
أوكي بعد قد إيه بالضبط؟ بداية 2015 تقريبا؟
والله ما أتذكر بعد فترة والله ما أتذكر يبين أنا عندي جبت الرسالة من دائرة اقتصادية متى طلع من كفالة سنة سنتين ما أدري والله أتذكر.
Okay. I don't remember the specific date, but I have the document from the Department of Economy, and it specifies when he was no longer under my sponsorship.
Would 2015 be right as a year?
Sorry, Mr. Ahmed was talking while the question was being asked.
That's right. Would it? I understand you can't be precise, but is it right that this was in 2015?
2015?
يبين أنا ما أتذكر إحنا.
I don't remember. You can look at the documents for that.
2015 بعد 3 سنوات تقريبا بعد فترة يعني.
Okay. Well, the reason I ask you is because your witness statement suggests it's a few months after, so I thought you did remember. That's why you said it's a few months after signing the loan agreement.
وأنت هنا قايل بعد أشهر قليلة.
أنا قلت بعد فترة. أنا يمكن ترجميني غلط. أنا قلت بعد فترة.
No, I said after a while. I did not actually mention I did not mention a specific period of time. I said after a while. Maybe the translation is not very accurate.
ما ذكرت التاريخ أنا لأن ما أتذكر التاريخ.
I did not specify any date.
Because I don't know them.
Okay, if I could please take you to page 265. Is that your signature?
Okay.
Yes.
Do you remember signing that document?
تتذكر لما وقعت
ما أتذكر.
No.
ما أتذكر. لأن العقود.
Is that because you didn't?
العقود ما عندي عنده هو.
He kept control of the documents, so I didn't have anything, and I don't remember.
Is that because, like the other documents we looked at, you didn't read this document either?
يعني أنت ما قريتش النسخة دي؟
أنا ما قريت الأمر كله أصلاً والله أقدر أحلف اليوم أنا ما أقدر على اليوم ما قريته ولا أعرف شو فيه أصلاً.
I did not read anything from this agreement, none of it.
And so it's entirely possible you signed that document as we see it on the page. You didn't read it. You signed it without reading that page.
يعني أنت وقعت الصفحة دي وبدون ما تقراها.
Yes. كان بين الأوراق يمكن.
Maybe it was just one of the many papers I signed, and it wasn't presented individually, so it was amongst the other pages of the agreement.
Could I then take you to page 26 of the bundle, please? Page 26, paragraph 7, please. So this can't be true. You can't say you didn't sign the receipt. At most, all you can say is you don't remember.
هنا في النقطة دي مكتوب إنه حضرتك أنكرت إنك وقعت الوصل اللي إحنا كنا دلوقتي فاتحينه. أنت أنكرت التوقيع عليه، بس دلوقتي بتقول إنك وقعت بس مش متذكر.
كيف؟
هنا مكتوب إنك أنكرت التوقيع على الإيصال.
أنا ما شفت الإيصال، أنا قلت ليه لاحظوا أنا ما شفت بين الأوراق كان أنا ما أتذكر أنه وقعت.
أوكي بس هنا مكتوب إنك أنكرت إنك وقعت ودلوقتي بتقول أنا وقعت.
لا أنا قاعد أقول أنا يمكن وقعت، ما أقول لك ما وقعت، يمكن وقعت بين الأوراق يعني وقعت بين العقود.
It's because
أنا ما وقعت ورقة لحالها.
It's because I did not sign it individually. So I cannot recollect if I signed it or not.
But
I cannot specify if I signed it or not because it wasn't presented individually. It was amongst the pages of the agreement.
يعني ما جاب لي الورقة لحالها عشان أوقع.
Could I then take you, please, to page 254? And forgive me for jumping between the page references, because you mentioned you didn't receive a copy of the agreement. Page 254, please.
Yes.
Can you see the handwritten bit where it says made in 3 copies, one to the lender, one to the borrower, and one to the lender's principal? And it has your signature there. You're confirming you've received a copy. Yes?
Okay, هنا مكتوب بخط الإيد إنه في 3 نسخ من الاتفاق. واحدة مع المقرض، واحدة مع المدين، وواحدة مع
ما عندي أنا، هو ما أخذهم وروح بعدين ما جاء.
أوكي بس أنت هنا وقعت.
هني وقعت وهني وقعت.
أوكي على
عشان يرجع مع الفلوس ما رجع.
Okay, I did sign. He took all the copies. He did not leave anything, and he said he will come back with the money. He didn't come back.
So you did take a copy of the loan agreement. That's right, isn't it?
لا ما أعطاني.
No.
But you've signed saying you've received a copy.
هنا أنت موقع إنك استلمت نسخة.
أنا موقع كله. بس ما استلمته. أقول خذوا روح.
I did sign, but I did not get a copy.
لا أخذ روح.
Because he took them and left.
ما رجع مع الفلوس.
Could I next take you, please, to the WhatsApp conversations? These start at page 314. Mr. Ali, these conversations are difficult for us to follow, so I'm going to ask you some questions to understand what you thought was happening here. So, page 314, and I'm looking at the line that's begins with, "Good afternoon, Mr. Ahmed." This is 15th of July, 2015. And it says, "My friends are asking if the land has been converted to commercial and sold." And then a week later, oh, sorry, it's a month actually, a month later in August, we see, "Boss, any news yet? They're continuously chasing me." Can you explain to us, when you received these messages, what did you think they related to?
هنا لما بعت لك مساء الخير أستاذ أحمد، الأصدقاء بيسألوني إذا الأرض تم تحويلها إلى تجارية وبيعت.
ما في أرض.
وبعدين ما فيش رد لحد يعني من هنا لحد سنة 2016، وبعت لك تاني في أي أخبار جديدة لأنه هم بيسألوني إيه اللي حصل. والسؤال هو لما كنت بتقرأ الرسائل دي كنت متصور إن هي عن إيه؟
أنا ما جاوب، ما كنت أتصور عن شيء، لأنه ما كان يسأل وأنا ما جاوبته، ما كنت.
أيوة، في تصورك الرسائل كانت تشير
ما
إلى
أعرف،
ماذا؟
أنا ما أعرف أصدقاء من أصلا، من الأصدقاء من يقصد يعني، ما كنت أعرف شيء يعني.
I did not respond
ما
because
جاوب، ما أعرف من الأصدقاء، ما أعرف من هو من يقصد يعني.
I did not respond because I don't know what is he referring to and who are those friends.
من الفريند، أنا ما أعرف فريند، ما أعرف أحد هذا.
I don't know who is he referring to.
ما أعرف منه أصدقاء.
And in fact, forgive me on the dates. I understand it's 2015 and 2016. We actually have a 12-month gap there between the dates.
Can you hold on a minute, Mr. Suleiman? I'm not entirely happy with what's happening with the interpreter. When Mr. Suleiman asks a question, then the question should be interpreted and the answer should be given by the witness, and there should not then be a discussion between the witness and the interpreter. She should simply interpret exactly what he says as he says it. You can wait till he finishes his answer, having made notes, and then translate it for us, or it can be done sentence by sentence. But having a discussion with the witness is not an appropriate way of dealing with the interpretation. Do you understand, Mrs. Interpreter?
Yeah, I'm doing my part exactly as you are saying, but once I start interpreting, he keeps interrupting me and adding more bits.
I understand your problem. I'm not blaming you at all. But if you can, yes, and if you can then, if necessary, translate, as I say, sentence by sentence. But probably better for him to complete his answer and then for you to translate the lot, having made your notes. If you can explain that to him, that would be helpful, so he can make it easier for you.
I will explain that to him. He is apologizing.
That's all right.
Okay. يعني لما يتسأل السؤال هترجم لك السؤال وتسكت لحد ما أترجم السؤال، وبعدين لما تجاوب أنا أترجم إجابتك جملة بجملة بدون ما تقاطعني أو تضيف أي أجزاء إضافية عشان ما يبقاش في نقاش بيني وبينك.
إن شاء الله.
I have explained your point.
Thank you. Thank you very much.
Thank you.
Thank you.
Thank you, sir.
If we could have a look over the page, please, page 315, the very top of the page. This is, Mr. Ahmed, this is your message. You say, hi, I know, but market is bad. Is that the real estate market in Dubai that was bad at that time?
دي رسالتك. Hi, I know, but market is bad. الماركت هنا اللي بتشير إليه هو سوق العقارات؟
نعم، كان يسأل الماركت أقول سوق زين ولا زين، لأن أنا مرة جاني قال لي بيشتري في عنده صديقي بيشتري أرض، فأنا طغشت له أشياء معينة عرفتها له.
I don't know if he's referring to real estate market. He said, I want to buy land. I sent him some options.
So this is your message. You were saying market was bad in that you were saying the lands are very expensive.
Market.
Okay. That land real estate price is very high. Is that the point you were making there?
أي سوق بتشير إليه؟ هل هي الأرض؟
ما أعرف أنا، أي واحد يسألني السوق شو أحوال السوق أقول له زين ولا مو زين. الحمد لله.
He asked me about the market, so I said the market is bad.
Further down the page, if we could look at the line that begins with Mr. Karthi saying, can I collect the cash from you tomorrow? This is 21st of July, 2017. So this is some 2.5 years after the loan agreement. You said no. Why did you say no?
طيب هنا تاريخ 21/7/2017 بعت لك ممكن اجي اخد الفلوس منك بكره وانت رديت قلت له لا. ليه رديت قلت له لا؟
لا لان انا تفاجأت بالعقود فقلت له لا.
Because I was shocked that he has agreements with him. He's presenting agreements. So I replied and said no.
What agreements did you think he was referring to?
لأن تفاجأت العقود عنده ما رجع له.
Because I remember that he has all the contracts and he did not give me anything back. He did not return them.
So when you received that message saying, can I collect the cash from you tomorrow, you understood that was a reference to the cash from the loan agreement? Yes?
لما بعت لك هنا ممكن اجي اخد الكاش، انت عرفت ان هو يقصد الكاش اللي في الاتفاق في العقد؟
اي لان تكلمنا بالتليفون قال ترى العقود عندي، قام يهددني فخليت ما راح تشتكي علي، قلت له روح ما في فلوس ولا شيء ولا شيء، ما اعطتني شيء.
Yes, because we talked on the phone, over the phone prior to this, and he said he has contracts and that he will present them to, like he threatened to file a case, and I just told him go ahead.
Why didn't you, Mr. Ali, at no point do you say what cash, what are you talking about?
ليه ما سألتهوش كاش ايه اللي انت بتتكلم عليه؟
أنا تكلمنا بالتليفون، له كان يهددني في العقود، يقول عندي عقد أنا معك. متى التاريخ هذا؟ متى التاريخ هذا؟
It's because we have talked over the phone, and he said that he has an agreement with this, stating this.
But Mr. Ali, your case is that he didn't give you the cash. He was going to give you cash, but then didn't. So why don't you say at any point, you told me you left the office to go and get some money and you never came back?
طيب انت دلوقتي بتقول ان هو ما ادالكش اي كاش، ما ادالكش اي فلوس، المفروض كان يرجع بالفلوس وما رجعش. ليه ما فيش ولا مسج بتقول انه انت ليه ما رجعتش بالفلوس، او انت اصلا ما اديتنيش فلوس، او انت كان المفروض تجيب فلوس وما رجعتش؟
ما رديت عليه لان حتى وديت الانذار من المحكمه وما رديت عليه انا ما عندي شيء انا ارد عليه لانه
I'm simply choosing not to respond even when he said he has a notice, because I don't have anything to respond to. I don't have anything to say to what he's claiming.
If we look same day, a few lines further down, this is in fact, if we look at the timestamps, it's about 1 minute after the previous messages. You say, late, see what will happen. I might say, let's see what will happen. It's not clear. But you're referring to something that may be happening, yes?
هنا لما كتبت let's see what will happen، ممكن هنا تكون الكلمة دي مفروض تكون مكتوبة بطريقة تانية، مش مشكلة، بس انت قصدك ايه بايه اللي بيحصل؟ ايه اللي انت مستني تشوف ايه اللي هيحصل؟
خلي اللي بيحصل حصل. قلت له انا يقول فلوس، قلت له اللي روح اشتكي عليه، اللي بيحصل حصل يعني سوري ترى لو لي حق.
Because when he said I will file a case, that was his threat earlier, so I was referring to that here, and I meant let's see where will that go.
Could I then take you to page 317, please? At the very bottom of page 317. The message, the very last message, in fact, from you, Mr. Ali, where you say, you're calling in WhatsApp and I'm out of Dubai. We're trying to do something, but still. Again, you're referring to something that's happening. You're trying to do something. Isn't that right? That's what you're saying here.
المسج دي بتقول له انت بتتصل بيا على الواتساب وانا برا البلد واحنا بنحاول نعمل حاجة بس لسه، فانت هنا بتشير الى شيء ما عم يحدث.
قلت له انا ماشي عشان كيف اوصل للحل معاه، يعني عرفت هذا اللي اقصد. انا شو اقول له انا؟ شو يقول لي نقرا؟
انت بتتصل بيا you're calling in WhatsApp and I'm out of Dubai. انت بتتصل بيا وانا برا مش في دبي. we're trying to do something but still احنا بنحاول نعمل حاجة بس لسه ايه؟ انت ايه هي الحاجة اللي انت بتشير اليها هنا في المسجات؟
المسجات يمكن عشان نوصل اروح اشتكي عليه اي شيء، يعني انا اروح اسوي اي شيء، يعني عرفت له.
I was referring
كنت برا الدولة، فكر اني ارجع اسوي له اي شيء يعني.
I was referring here to the process of like litigation or something like that. So I was referring here to if you file a case when I come back, because I'm out of Dubai, so when I come back I'll see what can I do also in that regard. That was that was what I was referring to here.
So to be very clear, this what we're looking at bottom of page 317, when you say we're trying to do something but still, you're not talking about the land or the market, the real estate market or anything like that. Is that right?
يعني هنا لما بتقول we're trying to do something but still انت هنا مش بتشير للأرض ولا للعقارات.
لا بالمشكلة اللي بيني وبينك.
No, I was referring to the issue that is between us.
اللي كاتب لي عليه هون.
The contract.
لأن فترة.
Could we then have a look, please, over the page 318 at the very top of page. Mr. Karthi says, this is what I've been hearing for the last 3.5 years. And actually, if we look at the date, the 3.5 years takes us to around the 2014 agreement. Your response, Mr. Ali, and I want to ask you about this, you say everything is bad, market is zero. So what you told us earlier, you were referring to litigation or the dispute. It's not at all. You're referring to the market explicitly.
طيب هنا هو بيقول لك أنا بقالي سنين، بقالي 3 سنين ونص بسمع منك نفس الكلام، وهنا أنت كتبت everything is bad market is zero، يعني الوضع سيء والسوق متدهور. فهنا أنت بتتكلم عن الماركت، عن السوق، مش بتتكلم عن
أتكلم عن السوق لأنه هو جاني. أنا عندي أرض مال الشيخ، يا أعطيته صور بعد مال الملكيات، زين يبي ياخذ. قلت له مرة كتبت له هذا السعر، ما أدري بأي شو بالواتساب كتبت له كان في أرض كبيرة في الجميرة، قال في ناس يبون يشترون يمكن نحصل شيء. زين فقلت له الماركت هذا الماركت تعبان، يعني أنا ما قلت له أن شو اسمه، أنا هاي اللي أقصد يعني. ما عندي يعني فهمني شوي، يعني قلت له ماركت مبزن.
It was because I presented him some option of land in Jumeirah, but I don't remember through which platform. And that was I was referring to when I said the market is bad here.
And so just the message above, the message to which you're replying, it's saying that's what you've been hearing. This is what I've been hearing for the last 3.5 years. That's referring to something that happened in 2014, right? 3.5 years before. And your response is everything is bad, market is zero. So you're quite clearly talking about the loan agreement and the land purchase out of the loan agreement.
هو هنا بيقول لك أنا بسمع الكلام ده منك بقالي 3 سنين ونص. انت رديت عليه وقلت له انه the market is bad، فهنا انت معناها انه انت بتتكلم عن السوق وعن الارض اللي كان المفروض تشتريها بالقرض اللي هو اداهولك. لا
مو هاي القصه، انا قاعد اتكلم عن السوق وما اتكلم عن الارض هاي، لان ما شرينا ارض شيء عشان نتكلم فيها. هلا ما شرينا ارض شيء عشان نتكلم فيها.
No, I was just referring to the market in general because we did not purchase a land so that we can talk about it.
I'll give you one final option if you want to correct yourself. On page 317, at the bottom of page 317, if we look at the timestamps, this is approximately 1 minute before your message about the market is bad. When you say we are trying to do something, but still, you're referring to land purchase and what you're going to do.
طيب هو هنا
pursuant to loan agreement.
إنه تتذكر أنت كنت بتتكلم عن إيه؟ هنا قبل المسج دي بدقيقة، قبل المسج دي بدقيقة، أنت قلت we're trying to do something but still، يعني إحنا بنحاول نعمل حاجة بس لسه.
عن شو؟
ما هو بيسألك هنا المفروض أنت بتتكلم عن الأرض، لأنه هنا أنت بتتكلم عن الماركت، فدي دي قبل دي بدقيقة.
هو ما قاعد يقول عن الأرض هنا، هو ما قاعد يقول عن الأرض، قاعد يقول عن الأرض هو.
Did you see him asking about land? Did he mention the word land at all?
Look, it's your evidence. If you're going to say that you're referring to, we're trying to do something, you're talking about litigation, and 60 seconds later, you're then talking about the market is bad and everything is zero. Your evidence is within 60 seconds, you're talking about 2 different things.
طيب ازاي هنا انت هتتكلم عن التهديدات اللي بينكم، ان انت لما ترجع هتشوف هتعمل ايه، وازاي بعدها بدقيقة بتتكلم عن السوق وعن الماركت؟
يتكلم عن السوق او عادي.
هنا انت قلت انا بتكلم عن التهديد وعن انا هعمل
وين
ايه بخصوص
هذا؟
التهديد. we trying to do something. لما كنت برا دبي انت قلت انك
طيب.
بتتكلم هنا بتشير للتصرف اللي انت تتصرفه حيال التهديد، وهنا بعدها بدقيقة 60 ثانية بتقول the market is
يمكن سألني عن شو هنا جاوبت أنا. اسمح لي شوي.
He wants me to explain to him the messages from Mr. Karthi before he said the market is bad.
The very next line after you say everything is bad, market is zero, Mr. Karthi then says, you give me the land details, what you bought with their money.
هنا هو بيقول لك اديني تفاصيل الأرض اللي أنت اشتريتها بفلوسهم.
What did you think this was in reference
هو
to?
يقول.
أيوة أنت بقى لما قريتها في تصورك هو بيتكلم عن إيه؟
هو هذا أيام التحديد اللي كان بيني وبينه يهدد أن انتشر.
That is because he already started threatening me with that.
But again, you are not replying, this is 2018, at this point you're not saying what money.
بس أنت ما ردتش ولا مرة وقلت له فلوس إيه اللي أنت بتتكلم عنها؟
ما رديت لأن ما عندي فلوس عشان أرد عليه.
It's because I don't have money to even respond in that way.
And in fact, what you are doing with your reference to the markets is that you're leading Mr. Karthi to believe that there's still some form of investment, that he should wait and that something will turn up.
بس مع ذلك مع انك بتقول ان معكش فلوس، انت كل مسجاتك بتدي ايحاء انه في استثمار جاي في الطريق وانه في حاجه انت بتعملها.
اللي جاي بالطريق مو بشرط انا وايد اشياء عندي اراضي مال الناس عندي عرفت له مثل ما عرفت عليه قلت له تعال اشتري هذا ما يشتري قال بيجيب ناس ما يشتري انا ما هددت ما قلت له انا فلوسك عندي وانا بشتري في الارض.
It's because I do have some deals and I presented him with an option. He did not come and buy it. It's not because I have his money. It's because this is my business.
Further down the same page, further down, there's a message from Mr. Karthi that begins with, you promised to pay. Its timestamp is 21:54:06 on the 27th of March 2013.
Okay.
Yes, so that message, I'll give you a minute to read that and it might need to be translated. But the point we made there is that he's saying you promised to pay and that there was going to be some 250,000 dirhams out of the 5 million dirhams given to you as a loan. And I think the reference almost 6 weeks is almost 6 weeks that that promise was made. And if we see the second sentence, it says, it's been over 4 years since I've made a verbal request and written requests. This is 2019, so almost 4 years again, just following the chronology. This is referring back again to the 2014 agreement, isn't it?
طيب هنا هو بعت لك انت وعدتني انك تدفع لي 250,000 من ال5 مليون درهم اللي انا قدمتها لك قرض، ووعدتني تدفع المبلغ ده قبل 6 أسابيع، ودايما كل مرة بتعطيني اعذار مختلفة، والموضوع ده مستمر ل4 سنوات من وقت ما كان عندنا اتفاق شفوي ومكتوب. هو هنا بيقول 4 سنوات، معناها انه هو بيشير لسنة 2014 وقت توقيع الاتفاق.
متى التاريخ هذا؟
التاريخ 2019 27/3/2019.
يعني 5 هو كاتب الكلام هذا، يعني في احد ياخذ يعطى 5 ملايين يقول اعطني 250,000 درهم. هذه كانت كلها تهديدات.
Do you think if he wants like I owe him 5 million, he will only ask for 250,000? It's just part of his threat that he's trying to present.
The message is quite clear. He's suggesting you pay something towards the 5 million. He's not suggesting that's the full sum. In fact, if we look further up above the page where we were earlier, Mr. Karthi says, I told you pay me small amounts to start with. You see the message? On 30th of August. So he's not suggesting 250,000 will be the total sum due. He's suggesting pay something is better than nothing. What you're not, the reason, Mr. Ali, I'm asking you this is that what you're not at any point saying, we're now in March 2019, nearly 5 years, 4.5 years after the agreement. You're still not saying what money. You didn't give me any money. You're not saying this at any point at all.
طيب 250
Why not?
250,000 مش معناها انه انت المفروض تدفع له 250,000. 250,000 كجزء من ال5 مليون، لانه هنا كاتب لك انك قلت لي انا طلبت منك تدفع لي مبلغ صغير كبدايه، عشان كده بيطالب 250,000 بالاشاره للمسج دي. فليه هنا احنا في 2019 وليه بيطالبك بالفلوس ولا مرة انت رديت عليه قلت له انه وات ماني او ايه هي الفلوس اللي انت بتطالبني بيها؟
ما رد عليه لان ما في شيء بيني وبينه عشان ارد عليه.
Because there is nothing to stand on to respond in that way, saying what money are you talking about, because there is actually nothing that I can refer to, so I'm not referring to that because there is nothing to refer to.
We can see just back where we were the previous message, the one on 27th of March. The very last few, the last sentence, the end of that, it says you haven't even given me a statement as to where the funds are. It's correct, Mr. Ali, that you didn't give any statement about where the funds are. Yes?
طيب هنا هو بيقول لك انت ما اديتنيش اي وثيقة او توضيح ان عن فين الفلوس دي. صحيح انك انت ما اديتلهوش اي وثيقة او اي حاجة عن مكان الفلوس؟
ما في فلوس عشان اعطي وثيقه على اي ما دام ما في فلوس، ما دام انا ما استلمت شيء، اعطيه وثيقه على ايش؟
How can I give him a statement if I don't have money? A statement of what? He wants to add a part.
Some 6 weeks. Yeah, sorry. Carry on.
Okay.
يقول له مش وثيقه اعطيه على شنو هو ما دام ما عندي فلوس، انا ما استلمت بالمبلغ، يعني مثلا اعطي وثيقه ايش ما دام هو ما اعطاني فلوس. كل تهديدات.
What document or statement can I present if I don't have any money to base that on?
Mr. Ali, do you understand why I'm asking you? Why didn't you say that at the time?
طيب هو بيسألك أكتر من مرة، ليه ما قلتلهوش فلوس إيه إلا أديك ستيتمنت عليها أو أديك وثيقة عليها؟
ما كتبت، هذا إنسان يغلط بل ما كتبت أنا، يا ريت أنا كاتب الكلام هذا.
I wish I did. People make mistakes. I did a mistake of not saying that.
We can see 6 weeks later, you can anticipate my question. 14th of May 2019. When it says, Mr. Karthi says, what are you doing? It's not right at all, Mr. Ahmed. You've been telling me the same story for over 4 years now about returning the money. It's pushing you for return of the money. Again, my question to you is, this is May 2019. All we see, your response says, I'm with the people.
طيب هنا هو كتب لك إنه اللي أنت بتعمله ده مش صح، وبتقول لي نفس القصة بقالك أكتر من 4 سنين عن رد المبلغ، وهنا إجابتك كانت I'm with the people. أنا مع الأشخاص.
أبي يروح مش جوابه، ما عندي جواب أجاوبه. أنا أبيه أصلا يروح يشتكي لأن ما عندي جواب أجاوبه عشان أنا ما استلمت أي شيء عشان أجاوبه.
I did not have a better response. I just wanted him to go forward with his claim because I don't have a better response to give.
Can we turn over the page, please, to page 319? This is June 2019. Your message, good morning. Mr. Karthi says, when am I going to get the payment? You say, sir, I'm waiting. You're leading him on, are you not? Mr. Ali, you're telling him that there will still be a point at which he will get his investment.
هنا انت كتبت له صباح الخير، سألك امتى هاخد المبلغ، امتى هسترد المبلغ، وانت كتبت له sir I'm waiting، يعني انا في الانتظار. فهو بيسألك ليه قاعد تمشي معاه على كلامه وتخليه يتوقع، خليني اكمل بليز السؤال، وتخليه يتوقع إنه في فلوس جاية.
أنا ما أقصد أني أوفي، أنا وشي أداري وأمشي لأن أوريدي متوهق فيه. أنا زين، أنا بالعربي بنسميه متوهق فيه. أداري عشان يروح يوصل المحكمة، يروح يشتكي، يروح يوصل، عشان أروح أخلص معه.
I'm just going along with what he's saying because I did not know what to do with this trouble that he is giving me for no reason. So I was going along with what he's saying to push him to go forward with his claim.
A few lines further down on page 319, your message on the 23rd of July. Mr. Ali, you said, I'm waiting for payment from them. It's coming. Can you explain that one?
طيب هنا أنت كتبت له I'm waiting for payment from them. It's coming. يعني أنا في انتظار إن هم يدفعوا قريبا. طيب أنت بتشير لي هنا؟
مثل ما قلت لك يعني ورا بعض أنا قاعد أداري عشان أطوف يمشي يعني. ما عندي شيء أقول له يعني.
I'm just going along with the conversation just to let him go away. Get out of my hair.
حتى بعد مرات.
He wants to add.
بعد مرات أنا شو أسوي؟ أكتب الكلام بالعربي أترجمه بالإنجليزي بالجوجل وأطرش له يمكن كان غلط ولا شيء يعني.
I sometimes used Google Translate to translate my messages. So sometimes I wrote them in Arabic and Google translated them and then pushed them forward to him. So I'm not sure if the Google translation was accurate about what I meant or not.
And a few lines further down, when Mr. Karthi says, you've been telling me the same thing since 2015. So we can see it quite clearly in reference to the loan agreement that was in December 2014. He says, you've been telling me the same thing since 2015. You will say, very soon, any moment, tomorrow I will talk to you. Again, Mr. Ali, what you are doing is leading Mr. Karthi to believe that there is still some sort of live investment in 2019.
طيب هنا هو بيقول لك أنت بتقول لي نفس الحاجة من سنة 2015. أنت رديت عليه قلت له very soon any moment يعني إن شاء الله قريبا في أي لحظة، وبعدين قلت له بكرة هتصل بيك.
نفس الكلام.
فأنت هنا السؤال هو ليه قاعد تضلله وتحسسه إنه في فلوس جاية؟
هو يمكن يحسسه إنه في فلوس، أنا ما فاصله، أنا بس أمشي يمشي.
I did not mislead him. If he expected money, that's his problem. I was just going along with the conversation just to get him out of my way.
What you were doing, Mr. Ali, is hiding the fact that there was never any investment.
أنت كنت هنا بتحاول تخبي حقيقة إنه ما فيش استثمار.
ما فيش فلوس أصلاً، مش ما فيش استثمار، يعني ما استلم شيء أنا مش استثمار، لا. ما استلم شيء.
That's because there wasn't any money to invest, not because there wasn't any investment.
Further down the page, 6th of August, Mr. Karthi says, good afternoon, what is happening with the payments? And your response, Mr. Ali, this is important. I really want to understand what you meant here. He said, good afternoon, sir. We are waiting for payment to come. He arrived yesterday there. Who's he, firstly? Who's the he that's referenced there?
طيب هنا يوم 6 أغسطس.
He arrived yesterday there.
6 أغسطس كتب لك مساء الخير. إيه أخبار الدفعات؟ رديت عليه قلت له مساء النور، إحنا في انتظار الدفعات. He arrived yesterday. هو قد وصل بالأمس. مين هو؟
نفس الكلام هذا الأيام اللي كان عندنا مشاكل 2019.
هو بيسأل مين هو؟
ما أعرف أنا مين. أنا كاتب لي ترانسليشن من جوجل يمكن عرفت ولا أول شيء ترانسليشن
جملة بجملة بس. جملة بجملة. I'll translate this part and then you can add.
Okay.
The same thing. We were already having the situation of threat here, so I don't know who is he. I might have used Google Translate. Shall he continue?
Yes, please.
يعني كل هالكلام يوم بدأت الماء عنده عقود وقام يهددني وانسحب من الشركة وقام يهدد وأنا أكتب له الكلام هذا أقول له فلوس جاي ناس جايين وفلوس جاي ما أدري شو جاي عشان يمشي.
It was the period of time when he withdrew from our partnership and started threatening me. So I kept telling him, yes, there are payments, yes, people are here, and referring to imaginary people just to let him go out of my way.
Mr. Ali, you knew that if at this point you said to Mr. Karthi that you were not going to give back his money, you would stop proceedings. And so you led him to believe there was still some live investment.
يعني انت لحد النقطة دي ما قلتلهوش انه ما فيش فلوس وانك مش هترد الفلوس وخليته يفضل مصدق انه في استثمار.
هو صار خليه يصدق يعني انا ما قلت له هو ما اعطاني فلوس عشان يكون فيها هو اصلا ما اعطاني فلوس عشان يكون فيها الاستثمار.
If he believed so, it's his problem. I did not get any money to invest in the first place.
You knew, Mr. Ali, that if you admitted or if you said to Mr. Karthi that you never received any money, Mr. Karthi would then realize he has been defrauded.
انت كنت عارف انك لو كتبت له انا ما استلمتش اي فلوس ان هو هيدرك ان هو تعرض لاحتيال.
هو يفكر كذي اصلا الحين انا تعرضت للاحتيال الحين انا تعرضت بالمليان لان القانون ما يحمل المغفل. انا تعرضت بالمليان لان اول شيء انا ما استلمت فلوس، زوجتي كانت موجوده والشاهد كانوا موجودين، اسمعني شيء ما استلمت اي مبلغ زين فانا تعرضت للاحتيال الحين.
If he thinks he had been defrauded, that's not my problem because I am the one who have been defrauded because I did not get any money. He was there with his wife. He took the contracts and left and did not come back with money.
Mr. Ali, in fact, you had no intention of investing when you signed this contract because you had no relevant expertise or background, or limited expertise or background in investment in land and real estate.
خبرتك في الاستثمار وفي العقارات وفي الأراضي محدودة صح؟
مو الاستثمار العقاري فيها بالكل شيء انا اصلا هو مو شغله بالاستثمار اصلا. هو لما انا اشتركت وياه في شراكه كان في الديكور ما الديكور اشياء بسيطه اسمعني شيء ديكور اشياء بسيطه زين.
Okay. Just a second. I really don't know what is the criteria of how much I have to let him speak before I stop him for interpretation. So can you let me know if I should let him finish everything and then translate that, or should he cut them into bits because it's
whichever is easiest for you. It's probably simplest if he gives his complete answer, you make notes of it and then translate.
Yes.
So he gives a complete answer to everything he wants to say and answers the question and you then translate. Can you tell him that first?
Okay. اديني إجابة كاملة ولما تخلص أنا هبدأ بالترجمة. Okay. طيب. So can we repeat this question?
Yes. You had, when you entered this loan agreement, you had no intention of investing in land and real estate because you didn't really actually have much expertise in that sector anyway.
طيب وقت توقيع الاتفاق أنت ما كانش عندك نية إنه تستثمر في العقارات ولا الأراضي لأنه خبرتك في الأراضي والعقارات محدودة. صحيح؟
خبرتي محدودة بس هني ممكن تروح تشتري شيء اسمعي لي شوية هني خبرتي مليون بس ممكن اليوم أي واحد يروح يشتري شيء فلوس عنده فلوس يشتري شيء اليوم يبيع بعد سنتين إذا في فلوس. إذا ما في فلوس يعني أنا عندي العقارات استثمارات شق قطر كلها عندي استثمارات عندي فوق 5 مليار اليوم يعني 6 مليار اليوم عندي أنا زين. فأنا قاعد يعني ما أقول لك ما عندي خبرة بس شوية يعني زين بس إذا كان في فلوس ممكن واحد يستثمر يعني في شيء معين عرفت يشتري شقة يشتري أرض يشتري شيء جديد بقيمة هذا زين. بس هو لما عنده خبرة ولا كان هذا كان نيته بايطة هو حقي أنا كان نيته بايطة أن شراكة بعد شراكة يا سوى العقد هذا أخذ العقد وروح.
Okay. So even if my experience is limited in a specific domain, anyone with money can buy anything and sell anything. I have investments of 5 to 6 billion dirhams currently. So I do business in every field. It doesn't matter how much experience I have. And he actually intended to let me sign the contract and then get out of the partnership because he had the malintention at that point.
I'm nearly finished with the WhatsApp messages. Just 2 more questions on that. Bottom of 319, please. The last 3 messages at the bottom of 319, when Mr. Karthi says, when do you plan to return the money? This is in November 2019. It will be 5 years soon. So this is approaching the exact 5-year milestone. And your response is, good evening, tomorrow I will call you. Again, Mr. Ali, you're suggesting you're going to have a conversation about this 5 years that have been since the money was loaned to you. You're not at all indicating that no money was given to you.
اوكي هنا لما سألك امتى هترجع لي الفلوس؟ امتى في خطتك ترجع لي الفلوس؟ الموضوع بقاله 5 سنين. انت رديت قلت مساء الخير بكره هتصل فيك. برضه ما رديتش قلت له مفيش فلوس ارجعها لك.
ما مثل اول مشيتها انا ما بيرد عليه مش ارد عليه شو ما دام ما استلم الفلوس زين اسمح لي شوي شيء واحد شيء ثاني بعدين بتقولين له انه هو هاي شيء هذا اول شيء زين ثاني شيء هو بدا ما في واحد يعطي 5 مليون يطلع من الشركه يعني يطلع شراكه يفتح شراكه وبعدين يروح يشتكي يقول تعال لو كان فعلا العقد هذا الفلوس عندي والعقد موجود كان ما طلع من شركه قال تعال اول شيء حل المشكله هذا. انت معي؟ يعني هو بعد ما طلع من شراكه معي راح طول العمليه هذا.
Okay. So as I said, and I repeat, I was just going along with the conversation just to push him away, and by logic, no one will pay 5 million dirhams and then break the partnership with the borrower, and only after that comes back and claims the money. And if he actually had if I actually owed him this money, he wouldn't have broken this partnership with me. He would have waited until this issue is resolved, and he would have called me and said, come and sit and let's resolve this issue first before withdrawing from the partnership.
Over the page, please, page 320. This is in February 2024. 5th of February 2024. Mr. Karthi says, hello, Mr. Ahmed. It is more than 45 days since you said you wanted me to discuss about return the 5 million I gave you in December 2014. So you met in January 2024, is that right? To discuss this loan.
طيب هنا هو بيقول لك انه مر 45 يوم من وقت ما قلت لي انك عايز تقابلني عشان نناقش امتى هترد ال5 مليون اللي اديتها لك في ديسمبر 2014. انتوا التقيتوا في يناير 2024؟
اتوقع ما ادري. طيب ما اتذكر والله متى التقيت.
I don't remember.
And over the page, this chronologically takes us nicely to the next few questions. When we go to March 2025, 17th of March 2025, Mr. Karthi says, good morning, waiting for the meeting. Your response, 17th of March, is good morning, inshallah, we will meet. And then Mr. Karthi says he's under a lot of pressure. It's now over 10 years. Which, if Mr. Ali, what I'll point out to you is, do you notice whenever I take you to any messages from Mr. Karthi, his time frames, and now he's saying over 10 years, each time he's referencing back to that time point, the December 2014 agreement. And in none of them are you responding by saying, what are you talking about?
طيب هنا مارس 2025 كتب لك صباح الخير في انتظار الاجتماع، وانت رديت عليه قلت له صباح النور ان شاء الله هنتلاقى. هنا سألك امتى، قلت له انا مضغوط هالفترة. هو بيقول لك انا مضغوط، بيضغطوا عليا، يعني في ضغط عليا، ومر اكتر من 10 سنين من وقت ما سلمناك الفلوس. فهو كل مرة هنا بيشير لفترة زمنية، كل الفترات الزمنية بتشير ل 2014 وقت توقيع العقد، وانت ولا مرة رديت قلت انه اي عقد او اي فلوس.
ما ترى هو انا قلت لك انا عارف ان ما رديت عليه لين راح المحكمة يشتكى لين دز الانظار من المحكمة دبي، لين ما جاوبت، لين حتى راح المحكمة دبي ما جاوبت انا، لان ما عندي اي فلوس عشان اجاوبه.
I know I'm not responding to that because there is no money and I just wanted him to go to court. He actually went to court, and even when he was at the Dubai court, and even when I knew that he has an official court notice, I did not respond.
And then we know there was a meeting on the 22nd of 22nd of May, I believe it was.
في اجتماع حدث في 22 من شهر مايو.
لا، في اجتماع حدث ما ادري مرة في كوفي شوب ما ادري وين، مرة ما اتذكر متى تاريخه صراحة.
I don't remember the date. I remember it was a meeting in a coffee shop.
متى كان هذا ما ادري.
I don't remember when exactly.
That meeting is the very first time you said to Mr. Karthi, I didn't receive any money from you.
في الاجتماع ده انت لأول مرة قلت له انا ما استلمتش منك اي فلوس.
ما استلمت فعلا وجه لوجه.
Yes, I said that when I was sitting in front of him face to face.
And prior to that point, there was no way for Mr. Karthi to have known that you were denying you had ever received the money. Because like you said, in your words, you said you were going along with the conversation.
قبل الاجتماع الأخير لما قلت له أنا ما استلمتش منك فلوس، هو ما كانش هيعرف إنك أنت بتنكر إنك استلمت الفلوس، لأنك كنت دايما بتمشي معاه في الكلام.
أمشي معاه بالكلام لأنه ما استلم شيء أنا. هو عارف أنه ما دفع لي شيء، هو عارف أنه ما دفع لي شيء. لو كان عرف أنه دفع شيء كان يشتكى من زمان. ما صبر 10 سنوات 12 سنة، كم سنة صبر؟
Yes, I was going along with the conversation, and he knows, he realizes that he did not hand me any money. Otherwise, he wouldn't have waited for 10 years to file a case.
Mr. Ali, the reason he didn't was because you had never before that point denied receiving the money.
هو ما رفعش قضية، ما اشتكاش، لأنك ولا مرة قلت له أنا ما خدتش منك فلوس.
كيف واحد تبي منه فلوس 10 سنوات و5 ملايين درهم وتصبر عليه تنام؟ سؤالي 10 سنوات، اسمح لي شوي، ما في واحد 5 سنوات تصبر عليه، 10 سنوات تصبر على واحد 5 ملايين درهم، وبعدين فسخ الشراكة وكل شيء سواه وخذ أغراضه كلها روح، يعني طلع اسمي كل شيء معي، يعني فسخ الشراكة وشم وراح بسبيله.
Even though he wouldn't, if someone owes you 5 million dirhams, you wouldn't wait 10 years to file a case regardless, and you wouldn't break the partnership that is between you and that person, which he did.
I only have a couple of more questions and then that concludes my cross-examination. Mr. Ali, during these proceedings, did you doubt that the signature on the receipt was your own when this case started?
بدأت أسئلة بس بسيطة وخلاص ونكون خلصنا. في بداية الإجراءات القضائية، هل أنكرت إن ده توقيعك ولا أي مرة؟
أنكرت.
قلت ده مش توقيعي ولا أي مرة؟
لا أنا ما نكرت، قلت له في بعضهم يمكن أنا مش متأكد أنا توقيعي، أنا ما نكرت أنا مش توقيعي، بس قلت يمكن في بعضهم مش، الله يعلم، يمكن بعضهم مش توقيعي، يعني مثل الرصيد أصلا يمكن أنا موقع وهو ورقة بيضاء، يعني يمكن أنا موقع، يعني فرضا الرصيد اللي قاعد يقول يمكن أنا موقع وأنا وقعت صراحة أقول لك أقدر أحلف كم مرة يعني مو مرة أن أنا وقعت بدون ما أقرأ بدون ما أطالع ولا شيء.
No, I did not specifically deny that I have signed or that those are my signatures. I just said that I don't remember. I might have signed.
شو وقعت؟
I don't know what I have signed. I might have signed some blank pages in between. Maybe that receipt mentioning the amount was actually blank at the time I signed, because I admit I have signed the whole agreement and all the pages without reading or looking at them. So I'm not denying at this point that I have signed. I have signed everything, not knowing what I am signing.
And when you and forgive me, I'll avoid going into anything that's privileged. And if anyone interrupt me if I do go into anything that's privileged. When you went to Matik Basoni's office with to inspect the documents, you brought your own copy of the agreements, didn't you?
طيب لما رحت مكتب المحاماة كان معك نسخة من الاتفاق؟
لا هم عندهم نسختين مختلفات، هم عندهم نسختين غير مش أنا.
No, they have two copies and I
هم
don't.
جابوا كوبي يعني ما جابوا الثالث بعد.
They did not bring the third copy.
What I'm going to say to you is that you brought your own copy to the meeting and you gave your own copy to your expert.
كارتي طرش
Yes.
بدي أتشل.
هو بيسأل إنه أنت كان معك نسختك لما رحت الاجتماع ودي سلمتها للخبير اجتماع الخبراء للفحص، كان معك نسخة؟
لا أنا عندي الصورة اللي سلمتها أظني الصورة اللي عندي.
أنا
عندي الصورة أظني.
I think I have a copy that they have sent me.
أيوة يوم فتحوا القضية طرشوا لي.
When the case was filed, they sent me a copy. That was what I had.
And that's an original copy.
نسخة أصلية؟
ما أتوقع أصلية ما أدري والله بشوف لأنهم طرشوا لي مش أنا. عندي بالمكتب عندي.
I'm not sure because they were the ones who sent it to me, so I have to look and see if it's an original copy or not. I have it in my office.
Mr. Ali, my concluding question is this, that you plainly were given a copy of the agreement at the meeting on the 11th of December, which you denied receiving.
Okay.
And now you're changing your account and saying it was given to you during this litigation proceedings.
بس ما أدري أصلية ولا مو أصلية ما أدري. عندي نسخة في المكتب.
فأنت قلت إنه ما فيش اتفاق بالفلوس وبعدين دلوقتي غيرت كلامك بتقول إنه كان في اتفاق وكان معك نسخة منه.
من اللي قلت حق منه؟
أخليه يعيد السؤال؟
كيف؟
أخليه يعيد السؤال؟
إيه السؤال؟
He doesn't understand the question fully.
I'm happy to leave it there.
خلاص مش مشكلة.
But if you want to answer the question, the question was that you were given an original copy at the time the agreement was signed.
وقت توقيع
On the 11th of December 2014.
سلموك نسخة أصلية في 11 من ديسمبر
ما سلموا النسخة
2014.
نسخة واو. أنا النسخة اللي عندي أظني حلو شيء هذول لما الجماعة لما فتحوا القضية طرشوا لي مع النوتس نسخة منه.
No, they haven't. I only got it when the case was filed. I received the copy that I presented.
Thank you. I have no further questions.
Any re-examination, Mr. Pacifica?
Just two very quick questions. So just to confirm, the partnership was terminated by the claimant, not by you.
الشراكة تم فسخها من قبل
That is a leading question of the worst possible kind, Mr. Pacifica. You ought to try again.
Apologies. Who there was a partnership between yourself and the claimant. Who initiated the termination?
طيب الشراكة اللي بينك وبين المدعي مين اللي اختار إنه يفسخها؟
هو يا قال أنا حصلت كفيل جديد أبي أطلع من عندك.
He did. He came to me and said that I have found a new sponsor, so I want to withdraw from the partnership.
Perfect. Thank you very much. Could I just draw the question to the supplemental trial bundle? Do you have a copy of the supplemental trial bundle? There. If we just turn, this is a copy of our expert report. Just to go to page 437, or I think that's page 6 of the supplemental report.
$437.
Yes, 437. Yes, if you have that there, and I think this just confirms the copies that were subject to inspection. 2 copies of the receipt, 2 copies of the loan agreement, 2 copies of the demand promissory note, and then the .d I think is not quite relevant.
طيب هنا في تأكيد عن عدد النسخ اللي تم فحصها. نسختين تم استلامهم وتم فحصهم بتاريخ وتاريخ النسختين دول 11 ديسمبر. نسختين من اتفاق القرض للمقارنة والاتفاق بتاريخ 11 ديسمبر ونسختين كمطلب للبروميسري نوت وكمان تاريخهم 11 ديسمبر بس تأكيد إن هم على العدد اللي مذكور هنا.
أنا استلمته.
That is what I received, he's asking.
Yes, that's your understanding. Just to confirm this, perhaps I would just simply say this is the content of the expert report. You can confirm that. Perhaps it's not even a question.
ده تقرير الخبراء وبيذكر هنا إنه تم فحص نسختين. فهل
صح.
أنت موافق؟
صح. صح.
I have no further questions for the witness. Thank you.
مفيش أسئلة.
Can I just ask you one question, please? When you were discussing matters with the claimant, you discussed those matters in English?
النقاش بينك وبين المدعي كان بالعربي ولا بالإنجليزي؟
والله شوي بالهندي أنا أفهم شوي هندي أفهم بس ما أعرف أكتبها وشوي بالإنجليزي بس أكثر شيء بالهندي.
The majority of the discussion was in Indian because I know Indian with some bits of English in between.
If your discussions were in Indian, why are the WhatsApps in English and why are the loan documents in English?
طيب ليه بدام أنت بتكلمه بالهندي إنك بتناقش معاه بالهندي ليه رسائل الواتساب بالإنجليزي وليه العقد بالإنجليزي؟
لأنه هو يكتب بالإنجليزي وأنا أترجم له بالجوجل أطرش له.
Because he texts me in English, I use Google Translate to translate Arabic into English and text him.
Right. Anybody want to ask any further questions arising out of that?
No, thank you.
No, thank you.
Thank you very much. Those are all the questions for you. So you're now free to come or go as you please. Thank you very much.
Thank you. Thank you, sir. خلاص.
And thank you to the interpreter as well.
Thank you.
So on closing submissions, I think there would be 2 options. The first option would be to proceed with closing now, perhaps subject to supplementing any closing submissions with any written statement. The other way to do it would potentially be to just the legal teams to revert remotely, say at 11 a.m. tomorrow. I'm agnostic as to which way to proceed.
I would suggest.
Well, go on, Mr. Sullivan. You say what you want to say, and I'll tell you what I have in mind.
My preference was to adjourn to tomorrow morning, especially because of some interesting live evidence that was just given, which we'd wish to digest overnight.
Right. I'm not in favour of having written submissions later. This is a short case. It would be easiest to get it all over and done with oral submissions. And I'm sure that will be more efficient and effective if you have time till tomorrow to prepare them. I think, Mr. Pacifica, you should work on the basis that I'm likely to find that the money was handed over. And in those circumstances, the vast majority of the argument will turn on questions of limitation rather than anything else. Of course, I don't have a closed mind, but I have heard the evidence, and you may want to focus on the matters that I suggest rather than others. All right. I hope that's helpful without being too discouraging, Mr. Pacifica.
Yes. Should we proceed at 11 a.m. tomorrow, Gulf Standard Time?
I suppose so. I mean, you're not going to be very long in closing in any event, are you?
Sorry, apologies. Could you repeat that?
I assume you're not going to be all that long in closing each of you.
I don't think it'd be more than 45 minutes each. I don't see that.
Yes, I was thinking an hour each at the most probably.
Yes.
Which is what made me think that we might start slightly later, which would save me having to have an earlier breakfast than usual.
Yes.
Would it be inconvenient to say 9 o'clock London time, midday Dubai time?
Yes, that's perfect for me.
And we'll just take a break at some convenient point between the two closings.
Yes. Would it be possible to get the transcript in advance of the hearing tomorrow, or is that too tight a deadline?
Well, they will do it if you ask for expedition, and what I suggest you do is ask for the transcript only of the evidence that really matters, so to speak. And I assume that essentially will be the evidence of the two main protagonists rather than anything else.
Yes.
It's just a question of trying to get them to do it in the time available, that's all.
Yes, we'll try to do that.
Obviously, it's helpful if you can.
Thank you.
If not, I have pretty good notes, and I imagine those who have been with you will have fairly good notes, even if you haven't managed to do that while you were cross-examining yourself. All right, that's very helpful. We'll say at midday Gulf time tomorrow then. Thank you very much.
Thank you very much.
Thank you very much.
If you would sign out, I'll have a quick word with the associate, please. When I say sign out, I suppose it really means you need to leave the court.
Leave the room, yes. We'll leave the room.
I'll wait while you leave the court, Mr. Pasivka.
Yes, thank you. Thank you.